Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. I'm sparking revolution, it's a truth-telling tale.
David Gingras, Rachel Juarez on Reality Steve. And people might be somewhat shocked about what I have to say. Um, my position isn't changing on anything, but um, let's say I understood Gingras a little bit better after that. I still think he's wrong on many things, but I actually understand his point now, whereas before I'm like, what are you talking about? Um, so that was interesting for me to be like, okay, I understand where he's coming from. I don't have to agree with you to understand where you're coming from, but that was something new for me. Um, I am making a banner just to, let's see, save. Oh, let me edit this one more. Okay. All right. So let's share our am I on the actual episode? Yeah. Okay. All right, we're going to bring this up. So we're going to share screen. Okay, and go here. There we go. All right. So we are going to watch this. If y'all haven't watched this episode on Reality Steve's YouTube page, it's interesting to watch. Definitely go give him the clicks and views. Because he deserves it, because he's the one who set this up. And Gingras actually decided to go on with somebody. So I'm shocked. I didn't think he was going to. Or if he decided to, I figured it would be after everything was over with, maybe. Or if things hit the fan between him and Owens. But I actually think that even if things hit the fan with him and Owens, that he's one attorney-client information, even though they waive a lot because they talk about stuff with third parties around. So, I don't think he'll ever come out and, like, give us candor or anything like that. But let's get this started. And I have notes. So, let's start here. And then I wanna make sure everybody can hear it as well.
Promise you that.
Yeah.
I got.
It's ding. I mean, without any further introduction, let's bring him on.
Point.
It's Baby King. It's Dingus.
Yeah.
You even put your name in as Dingus.
Steve, you don't
Can
know me that well,
everybody
but
hear
as we go
that?
along here, I'd like to think at some point you can figure out I got a little bit of a sense of humor. It's not very good. I'm not Dave Neal. But I'm like,
All right. With 5 seconds
Okay,
in, you're
good.
fucking taking shots at Dave.
I have to talk about Dave. I'm not taking shots. I brought my Trump mug for those who celebrate, which is
So I
not
just
me.
want to play
is
this
sarcasm.
part because it just shows you
Thank
kind
you
of
for
the
having me
beginning
on. I
where
appreciate
everything
it. This
is
is going to be a
normal.
friendly debate. I promise you that.
Yeah.
I got
Kinda
I
how
have
he's
no ill will
being.
towards anyone sitting on this screen.
It's just everyone else online you have ill will with.
I only sound that way. I promise you that. Again, you don't.
He had to choose his words carefully because he was like, I don't have a problem with anyone on this panel. Because he has problems with people. He definitely has problems with people.
You can only go off what you present to us, which is
Fair
I'm
enough.
a dick, and I'm going to go off on you trolls. That's
More reason to have done this, and I appreciate you giving me the opportunity to talk
Yeah,
to
he
you
does go
guys.
off on people that he
And
considers
this
trolls.
is I can't believe looking at the calendar that it's April the 3rd, right? 2025.
Yeah.
I remember a year ago getting hired for this. It was literally March 25th, I think it was, something like that.
Yeah. And
I was the guy who kept saying, I'm going to try to do things right, and I'm going to try. I don't know all the facts, and I'm still partially. Yeah, well, I'm still partially, burdened by that, and you and I have talked a bit now, and I've emphasized to you that I'm super happy to talk about, everything from my involvement forward to the extent that I can. I'll comment a little bit about some past things that I wasn't involved in, but I told you, Steve, that I don't want to fight you about the law because you're not a lawyer, and I don't want to fight you about the facts that I don't know because I wasn't involved in. Doesn't mean I don't care. Doesn't mean I don't care. Doesn't mean I don't think they're important. But I don't want to.
No, I think he thinks that those things are not important. And if you are a lawyer, you cannot tell me that you haven't gone into this case and learned everything that happened before. Because you need to know what documents have been filed, what evidence do they have from you, what all the motions that have been done and everything like that, because you need to make sure that they haven't missed something. Just like he's like, oh, Rule 26, when Alexis Lindvall is the first one who brought up the Rule 26 thing. And it didn't go far with her. She left the case. But so I would like to actually hear her reaction to what Gingras is saying, because she did talk about Rule 26 and how they didn't, serve her with something separate. And then, later it wasn't until she was with Corey Keith that she was wanting to drop the lawsuit, I believe, because she was no longer pregnant or anything. But for him to sit here and say, I don't want to argue about the law with you, like he'll argue about that with Rachel. And he doesn't want to argue about facts from before because some of it he doesn't know. Well, it's your job to know. And you haven't done your job if you don't know everything that's going on with your client in this case. the line of, oh, it was before my time is bullshit. You don't just come on a case and you're like, yeah, I just take it from here and I don't look at anything else before. Like, to me, that would be malpractice. Let's continue.
Misstate anything. I mean, people are so hanging on errors, right? I mean, my Twitter was just blowing up over people, and I don't know if this goes back to Mr. Neal. And am I allowed to talk about him? I mean, I'm not going to beat the guy up.
You can, but we'll take it on a case-by-case basis
Okay.
of what you choose to say about him.
Fair enough. But somebody on Twitter was blowing me up because they said, oh, MATA made a finding, or that there was a December 2023 RavGen test, and I don't know why they thought that was significant, that there was this December 12th or something. I literally just was tweeting about it, and they were saying, oh, Dingus doesn't know about all the facts of the case. And I was like, what are you talking about? There was no December test. And sure enough, it's one of those things. You go back to MATA's post-trial findings, it's there. There was no exhibit about it. It wasn't talked about at trial. It was just, we figured out where it came from. It came from Woodnick's pretrial. He just put it in there, but there's no exhibit.
So once again, he is saying that Woodnick is just putting make-believe stuff up in a story, and that there is no evidence proving any of this. Like, there are dates, there are receipts. Clayton knows when he submitted things, and that she did. So for her to sit here or him to sit here and be like, well, I don't know where they got it. Because Laura says she didn't do that. Well, Laura says a bunch of bullshit. So excuse us for not taking her word. And you just want to say, oh, well, he just put it in emotion. Like, he just put a bunch of words and things that were not true in there. So you're accusing him of knowingly lying in a court document, doing unethical things. Like, you need to be able to back your allegations up, sir. I wish I could do live facial reactions, but the camera on my computer is not working. So I've got to get something and figure that out. I am not tech savvy at all.
But there's no document. I've never seen such a test. I don't know if it's a typo, whatever. But you know what I mean? That's my attitude going forward. I really want to be careful, Steve. I actually do care about accuracy, truth. Everybody does make mistakes. We make typos. We misspeak unintentionally. I don't want to do that. That's part of my hesitation to go into areas I'm not familiar with, if that makes sense to you.
And I just wanted to let everybody know, for the record, we're going to have a good 90 minutes to 100 minutes on this. And we're not going to get to everything, because a lot of people that are going to be watching this video are obviously the people that have been invested in this case since long before you even took over for Laura. So there's a lot of people that are interested. I know they have a shit ton of questions. We're going to get to as many as we can, but we're not going to, there's no way we can cover everything, because you and I both know we can talk for 5 hours about everything that's been involved since you took over in the last 10 months.
How much time would you say, and I'm not trying to ask you to reveal any trade secrets here, but how much time have you and I actually spent talking? Because we haven't had
4 phone calls that were back in November and December, which were around 30 to 45 minutes each, and then our phone call earlier today, which was another hour. So maybe close to 4 hours total.
And to me,
and then texts.
It feels like, Steve, that we're just scratching the surface. I mean, we really are. And I realize I want to get information to you, so let's get into whatever you want to get into. Chatting and talking is nice and everything, but I know you have questions. You hit me up with some of them today. I'm going to do my best to talk about them, and I actually genuinely want to hear Rachel's input. I do. And Rachel, I'll tell you, because I've never spoken to you directly before.
He doesn't care to hear her input. I don't know why he says that. I mean, maybe he does from another lawyer. He wants to speak to lawyers, but just like he did with Omar, the tilted lawyer, if you don't agree with his opinion, he now doesn't care. He doesn't want to hear about you, and he's going to possibly badmouth you. I don't know if he has said anything about anybody since this. Like, I don't know if he's disparaged Rachel or anything. I haven't heard anything or seen anything, so I'm guessing not, which is good. And if he hasn't, that shows that he can have a somewhat civil conversation and not be an ass. So why can't he do this more?
For that, the entirety of my knowledge of you is limited to listening to the one thing that you and Steve did, that I did a live stream after. I listened when I drove down to Tucson to pick up my niece. I listened to you guys and I loved it. I thought it was great. I have massive respect for Yale. Did you go to Yale? Is that what it was?
She's been on his show many times.
That's shot. My dad went to Dartmouth. I know what that level is like. And so if I ever say anything as we go along here, like
you do not know what that level is like because your dad went to Dartmouth. Because you didn't go to Dartmouth or a higher up school. And also, you weren't around when your dad went through all of that. So you don't know anything about what the level that is. Like, trying to be relatable when it's like, well, because my dad, you have no experience with it just because your dad does.
Ask you how many appeals you've worked on, and if the answer is not very many or whatever, please understand that you have my complete and total respect. I'm not questioning your skills.
That's okay.
Fair enough. Okay, so Steve,
so basically what I wanted to do is just let everybody know right off the bat. We're not going to get to everything that I know some of the people out there want, but we're going to cover a lot. And what I like to do in my interviews is kind of go chronologically. There will probably be some things that will bring us back to something when you give an answer. We might have to go backwards a little bit, but I want to go chronologically, and I want to kind of start at the trial. That was in June of last year. And I'm not going to sit here and be like, hey, when Dr. Medchill said this, we disagree. We're not going to do that. But there are two general questions. And when I say I want to know, I'm also, I think, taking the consensus of the Justice for Clayton crew.
I think what Reality Steve is saying here is we would love to answer all these questions and stuff and get all the answers. But Gingras is not willing to have a conversation about them. Either because that will get heated, or Laura would get pissed off, as well as some attorney-client privilege or something, but I don't think he wants to get into any of that. I think Steve would get into a whole bunch of stuff if Gingras allowed him to, but Gingras is the one that kind of set the rules out, and Reality Steve was like, okay, like, we can adhere to these rules if you come on the show. And a lot of people do that for interviewers. They're like, these are the things that we can talk about, and then these are the things that I absolutely won't talk about.
When they want to know certain things. So I'm going to be like the mouthpiece. A lot of this thing will be me just moderating and just getting us from topic to topic. I'm sure there will be some memes where people can make, so I'll probably have some facial reactions, some eye rolls, whatever. But
from this guy,
yeah. And then I'm going to, and if I'm not looking at you guys and I'm on my phone, it's because I'm making notes on my phone because I don't want to type because the sound will get out over the air. So I will be looking at my phone to just take notes and maybe give myself a, hey, ask this or whatever on a follow up or something.
Okay, so we're June 10th, 2024, lovely warm summer day in Phoenix. Let's go. Let's go back in time because it was a lovely day for me.
So for June 10th, for the trial, there are two things that stick out for me and a lot of people that we want to talk about in generalizations of the trial. The first question is this. You never got a chance and you never got around to cross-examining Clayton, which to a lot of people was just like, why did he waste 45 minutes or whatever it was? It might have been 40 minutes on Laura on stuff that the judge probably already knew. We all already knew. She didn't say anything that we didn't already know. It had been in depositions and stuff. And you never even got around to cross-examining the one guy you would think, you being the guy that you are, probably wanted to grill him like no other. So what is your answer to why you never got around to cross-examining Clayton? And did you want to cross-examine Clayton?
So it's such a good question. I totally adore this question because I would ask the same thing if I were in your shoes or JSU's shoes. Why would you not talk to like the main guy, right? Obviously, time was not allowed for all the things to happen. But prior to trial, I had, and I think we agreed that 4 people testified, right? It was Clayton, Laura, and the 2 experts, Deans and Medjo. That was it, our cast of 4. I had binders and notebooks ready to go for like 10, including their forensic expert, Gillespie, Maricini. I had a full list of questions because I just naively thought that this 2-hour thing was maybe going to be flexible. But once Judge Mata told us in the morning when we first got there, she said, "I'm not giving you a second more time." In fact, it was worse.
I could understand some binders for like Maricini and Gillespie if you have like text messages and like the whole court filing stuff in there. Like having a binder for each witness. But I would think the amount of stuff that he needs in his little binders, one, you could probably fit it in a big, huge binder and just have everything sectioned. Because this isn't a big case. It's not like a criminal case where you need all these different binders and everything like that in them. And like he could probably use a 3-prong folder, like, or just a little file folder. Like, nobody's talking about binders and binders. He did not bring binders and binders into court.
Worse than that. When we walked into her chambers and had our initial sort of meeting, she said, "Look, there's something called invoking the rule, and invoking the rule is called the rule of exclusion. Normally, if you've ever been to a trial, people that are witnesses, expected trial witnesses, are not allowed to sit in the courtroom and watch if somebody invokes the rule. It's if you're a witness, we kick you out." Okay, and so Mata said, if you want to invoke the rule, which is normally just to prevent witnesses from hearing what someone else said, so they can kind of make their stories line up. It's a good rule, but she said, if you want to do that, I'm going to subtract the time it takes for people to walk to the courtroom from wherever they're waiting, and I've never, ever in my life had a judge say something like that. I appreciate Rachel's reaction.
You've never been in front of David Carter, have you?
That's interesting, Bruce, because I just don't see how he would have a binder on the forensic person. Like he would have the report, okay. And then I could see him having one on Greg and Maricini, but he also likes to say he doesn't know anything about them, really. So how do you have a binder of information if you supposedly don't know anything about anything? And like you can have pages of questions, but like, and I can understand like binders on Clayton and everything like that, but I don't see you having like 10 binders, like one for each witness. I just am not seeing it. Like I imagine everything in this case would take up binders and binders, but you did not have binders of information, sir, on all the witnesses. I am not going to believe that. And if he did, then he's lying when he says he knows nothing about anything prior to him being on the case. Because if you have that information and you were prepared to question them because you have to be prepared, then how do you not know about this stuff? Like, you can't have it both ways, dingus.
I have not. I've done jury trials and bench trials, and judges, I think, generally look at flexibility as being the standard because due process is not a joke. We try to have a fair hearing, even if sometimes we have to be flexible. You know, and Mata made it very clear that she was not flexible and was going to be extremely harsh on this time thing. And that's why when we came out of there, I was like, my God, we can't, if we have witnesses walking to the thing for 5 minutes and I've got 50, I'm like, okay, everyone just stay here, which is why everyone was allowed to remain in the courtroom, which that shouldn't have been done that way. To answer your question about Clayton, I had a list of questions for him. I had a list of exhibits for him. And by the way, I don't know if people know this or even care. My entire exposure to Mr. Echard, we had a settlement conference the court ordered us to. I actually told Greg that I would be willing to have him and Clayton and everybody sit down in a room. I mean, that's what you would normally do in that situation. I am a big believer in meeting.
But this situation is not normal, David. Like having
mediation, arbitration,
a client that they don't want to all sit in a room. Now, could you have had a Zoom call? Sure. But this is not a normal situation. You have a woman who is accused, an attorney and their client, of ARPing. And it's not the first time she has accused an attorney and a client of ARPing. Because before it was with Gillespie and Woodnick. And then Woodnick didn't get re-accused, but he's still accused from when she did it. And then she accused Clayton. So yeah, they don't want to sit in a room. They can talk to you, but they don't have to talk to Owens. Because you represent her, there doesn't have to be any communication between the two of them. It's like, talk to my lawyer. If you have something to say to me, you can say it to my lawyer. Like, you don't have to. So and this is not a normal situation. And you believe in mediation and all that, but like, how do you mediate this situation where if y'all are all in a room together, like, she's not going to come up with more off the wall accusations?
And people working out their disputes. I'm a big fan of that. And you can't resolve things unless you talk, right? So I offered that, and Woodnick refused. He wouldn't let Clayton and Laura speak to each other, but I talked to him on a Zoom. It was me and Woodnick and Clayton. So
they're not allowed to speak to each other. They have attorneys so that they don't have to speak to one another. So ridiculous.
we had a conversation. I don't even remember how long it was, maybe 15 minutes, something like that. And I didn't watch Clayton's season of The Bachelor, so I didn't know anything about him. I didn't know anything about this case before I got involved. I just knew him for 10 minutes on a Zoom. Okay, but getting back.
Sorry to be stopping again. I haven't watched Clayton's season of The Bachelor either. I've seen bits and pieces. I know certain people from his season, but I haven't sat down and watched his entire season. I just knew he had been on The Bachelor. But that was the extent of my knowledge. So you don't have to have watched him on TV to know anything about him. You should have read up on this case and you would learn about him because it's your job.
Getting back to your question, why didn't I ask him any questions? Number one, there wasn't time. And number two, when I thought about it before trial, and I was writing my questions and thinking about what do I need this guy for? What do I need Clayton? Because that's really, whenever I get involved in a trial of any kind, I always start with, literally on day one, I start with jury instructions. I start with jury instructions. That is what you read to the jury at the end of the case. And I do that from day one when I'm starting, because the jury instructions.
Meredith, like, as you said, like, it has nothing to do with his season. And maybe that would be important if Owens was a contestant on The Bachelor and they had met that way. But that's not what happened. This was after The Bachelor. Has nothing to do with it. And then here he's talking about jury instructions. He starts with jury instructions. Sir, this was an evidentiary hearing. Why are you, and you know there was no jury. Why the hell are you talking about jury instructions? You start with jury instructions to format your arguments and stuff. Well, there's no jury here. So what are you talking about? You're just rambling bullshit.
Instructions usually have a list of elements of what the case, what the claims, what you have to prove to win your claim or to defeat a claim. So you need to know what those elements are. And then you focus your discovery on getting those elements proven or disproven. You follow me? There was no element to our trial that required Clayton's input. There was not. And this is something, Steve, I'm going to ask for you to be flexible and open-minded, okay? I'm going to give you the same courtesy, and I'm not suggesting that your views on this are wrong. You're just a guy who's interested in a case and the situation and the people involved. Totally fair, totally understandable. I don't look at it that way. I look at this like a doctor looking at a patient on the table in front of him. You don't even see a person, right? You just see the body and like what organ you're working on, and you just think, what do I need to do to get this person off the table and onto the next thing? So I thought about, what do I need Clayton for? Absolutely nothing. What issue could he testify to that would make any difference to the issues that were subject to the hearing on June 10th. Like, I still think the June 10th hearing should never happen, first of all. if the issue was really just limited to sanctions, do you think that's what it was? I think it kind of was. I think it was broader than that. I think Woodnick was trying to prove that Laura lied about the whole thing. I think that's what he wanted the hearing to be about. And that really is what it was ultimately
because
about.
he was trying to prove that he wasn't the father
from my
of those
perspective, this was a
babies.
petition to establish paternity. That is what Laura filed, a petition to establish paternity. And she checked a box that said there should be a parenting plan. All right. She, on December 28th, told the court, I'm not pregnant anymore. There's no child coming out. Not 1 minute of time was ever spent talking about parenting plans. The issue of paternity, I
She took
saw
a
it
class,
as being
so
moot.
there was something.
So really, we didn't need to fight over that. Fighting over attorney's fees, should there be fees awarded? Again, I think Clayton's approach was Laura was never pregnant, therefore I get fees for everything, right? And that's what actually ended up happening. I don't know if the question boiled down to, and in the sanctions context, I think, and Rachel, please, disagree with me if you think I'm wrong. The question for sanctions is usually not, is the person right or wrong? The question would not have been, if we were only fighting over sanctions, it would not have been, was Laura pregnant or not? The question would have been, did she have reasons to think that she was? Even if she was wrong. If she made a good faith mistake, Rachel, I appreciate you're nodding. You think I'm right.
Whether she ended up being right or wrong.
She could end up being wrong. Any lawyer who's been around.
And all of us have said that, is that if she had a true belief that she was pregnant, she can file a case. Absolutely. And then the babies don't ever come to fruition. She could have done that. Or if she was pregnant and she thought, you know what, Clayton and I did this, and then I had sex with Joe Smo over here, but I think most of the time when moms are doing this is they will go after the first one they go after is the one they want to be the dad or has the finances that they can gain from. That's usually who they would go after first. And so even if that was the situation and she went after Clayton and she was pregnant and Clayton wasn't the dad, it was actually Joe Schmoes, she would have been okay with filing this case. It would have been okay. Because there would have been a baby. Had she come into this and actually had like a sonogram, or there had been some fetal DNA in these Rapgen tests, it possibly would have been okay for her to file this paternity action. But when you know and you're doctoring evidence to prove that you're pregnant, you're not pregnant. Because you don't have to doctor evidence if you are in fact pregnant, because the real evidence will just say it. You have to mess with it when the evidence doesn't prove the story you're trying to sell. You can. You absolutely can determine paternity fetal DNA in the mother or in a miscarriage material, and they failed to do either. She can't. And that's the thing, is nobody is disagreeing with him on that point. For some reason, he thinks that everybody thinks that anybody in her shoes that could have thought they were pregnant, like, could have filed this case. When nobody's arguing with that. I would even say if somebody took 5 HCG tests and filed this and thought that they were pregnant, but didn't doctor any evidence, didn't have a sonogram, didn't go to the doctor, and then let's say they did miscarry, or it ended up being a false positives on the HCG test, and then they dropped the test, I would even be okay with that. I think all of us would understand that even. But it's the fact that she doctored evidence and she continued with her story that we have a problem with. We wouldn't even care about the 5 HCG test if she hadn't done all the other stuff that she did. Like, she cost him DNA testing money. She cost him attorney's fees money. Like, she should have to have paid for every single dime of his DNA testing stuff that he did, because that stuff isn't cheap. Because he's having to take those tests for no reason if she knows that there is no baby, which is, I believe she knew there were no babies. And she just made him spew out all that money because he didn't want to have a relationship with her. All right, let's get back to this.
Been around the block more than a few minutes, has been involved in cases where you start out thinking A and you wind up realizing that A is not correct. Okay. That is not, you don't get sanctioned for being wrong. You get sanctioned for being knowingly wrong, or for being wrong and not having a good faith basis for thinking that you were right. So I saw the issue as being so unbelievably narrow, limited to, did Laura have any good faith grounds to think that she was pregnant? And yes, I know that the comeback to that, I know exactly what your response to that would be, because I would argue that how would a woman prove that she had a good faith basis to think that she was pregnant? Well, I hooked up with a guy and Laura says he put it in. Okay. You don't have to believe that or whatever. And she gained weight and boobs grew and she felt pregnant. That I could argue that nothing more than that is needed to give a woman a basis to go to court and say, hey, I think
where did the boobs grow? Where did the boobs grow? They didn't. I gained weight during COVID. Because what else was there to do than stream stuff and eat? Because I couldn't go to work. But doesn't mean I'm pregnant. Like, you can gain weight, and then if she has issues with gluten, you're going to gain weight from that. And then, but no, that's enough. That's not enough. A woman cannot go to court because she got fat, and when you get bigger because you gain weight, your boobs do get bigger most of the time. And when you lose weight, a lot of times your boobs will shrink along with it. But just because you gain weight, and because boobs are fat, just like the rest of us, like our bellies and stuff. So, of course, if we gain weight, we're going to get fat in the fat areas. Doesn't mean you're pregnant. Yes, Bruce, anyone can file a case, but then you have to prove your case at some point. That's the thing. Anybody can sue anybody for anything, but it doesn't mean that it's going to go anywhere. I could sue Bruce for leaving a comment on my YouTube. That doesn't mean that I'm going to win. If I'm like, I think because Bruce left a comment, I think he owes me $1,000. I will get laughed out of court, but I could try to sue him for that. But I don't have anything to prove that he owes me $1,000 for leaving me a comment. And exactly, her boobs didn't look big when she was riding horses. She didn't have a belly when she was riding horses. Where was all that fat that she gained, supposedly, when she was riding the horses? And also, pregnancy isn't fat. Like, I mean, I guess it kind of is, but it doesn't produce itself in like the way our our fat is. It comes off round and smooth and hard, like not blubbery. Like, my lawyer will be contacting. Yes, tell Omar he can contact me. I'm gonna be pro se though, Bruce. So, you can have a lawyer, and I'm gonna be pro se, and I'm gonna win this lawsuit.
think I'm pregnant. I think this guy's a dad. Can we have a test? You might wind up being wrong, and you know the story, Steve. This literally happened to me. I was sued for paternity. I was not the dad.
God, I
It took
hate
5 minutes, and it was no big deal.
story
Take
of
one
There
test.
was a child that was born out of that.
There was a
So
child.
you know, there was at least a child born.
Not mine. Not my
Yeah,
child. Not my
right.
child.
Sure.
But look, I didn't blame that girl. And I guess what happened. Anyway, we could again. I don't want this to be a 12-hour
You do blame
conversation. I
that
had a
girl.
lot to say on this. I'm
You
gonna try
have
and
a lot
stay
of
focused.
resentment towards
I
that
really
woman
thought that
taking you
the
to
issue was
court.
as limited and narrow
Like,
as did
you're
tell the
still
court why
talking about
Laura
it
thought she
years
was
later.
pregnant. 5 positive pregnancy tests before she filed the petition. And this is where Steve. Yeah, I hear you. And thank you for letting me talk. I'll let you retort in a minute. I know this is your show anyway.
I'll let
Again,
you
if the
speak on your
standard is, did
channel.
Laura have any grounds at all, any good faith, reasonable grounds to think she was pregnant? I was focused on that. Clayton's testimony really had nothing to do with whether or not Laura was in fact pregnant. Clayton would have no idea. He would have absolutely no knowledge after he had his what day was it? May 30th, whatever day that happened.
Yeah.
Whatever day.
The
That was.
You
hookup?
don't
What do they call
even
it?
know
After that
the
day,
date.
Clayton knows what
If you're
happened that night,
okay.
and he already kindly wrote an email where he said, "Yeah, there was enough contact that pregnancy was possible," which everybody misrepresents that and says, "Oh, it's no big deal." He said it. And thank you for being honest, Clayton. And then after that, what did he have? Laura came over to talk to him one time.
Thank
He
you
gave her
for
a test.
being
She took it. It was
honest.
positive. That's the extent of Clayton's knowledge. He has no knowledge of what she did after that. I mean, yes, he has knowledge of her emailing him. He has knowledge of her behavior. That goes to, I think, a completely separate issue. That doesn't go to, did she think she was pregnant or not? I mean, and I understand why, if you look at this like a movie script, it all fits together, right? It's all part of a big thing. And it's the theory of this was a fake pregnancy used to manipulate the guy, blah, 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 blah. That was the theory, right? I thought, in my opinion, that the evidence of that
theory
was
was
either
proved
not relevant at all,
correct.
or that it was just so. How can I explain it? What if I had 8 hours to cross-examine Clayton? What would I have asked him? Like, did she send you mean emails? Well, yeah, okay. Does that mean she wasn't pregnant? I mean, I just felt in the time that we had, I had to focus on, had to prioritize things. Clayton's conspiracy theory about what he thought Laura was really up to me, it was like number 10 on the list of things that were important. So I just, when Mata made it clear that I didn't get anything more than the bare minimum of time, I took my pile of notebooks and I chucked out everything but the absolute most critical things. So I didn't think that Clayton's testimony was going to help or hurt our case in any meaningful way. So I didn't ask him any questions. I would have liked to. I really would have liked to. But my questions, because I told you I had 5 pages of notes written to ask him. Things like, did you lie to Laura about the real estate contracts? Right? I can impeach his credibility because he lied to her. He did lie to her. Does that change the case? Does that change the pregnancy? Not really. I mean, what are your thoughts, Rachel? I'd love to hear.
Rachel, yeah.
As he talks about did she send you mean emails? Okay, what does that have to do with the pregnancy? Well, the question of, did he lie about real estate? And the answer could be like, yeah. But my answer to that would be, well, how is that relevant? Like, but this is somewhere where, yeah, the conspiracy agrees, fraud fits the evidence. Yes. This is where a lot of us were questioning, like, I can't believe he didn't save time for Clayton and to question Clayton. And the thing is we would have liked to see it just so we could maybe laugh at how stupid it was. But I actually, for Gingras's position and Laura's position in this is to prove that she believed she was pregnant and that she didn't lie about that. So in trying to prove that, I agree that calling Clayton for their case does nothing for them. Calling Clayton does not help Laura prove that she didn't lie about pregnancy, that, she was this good girl who just, had a miscarriage and she's not this cray-cray. So I agree that he did not need to cross-examine Clayton because it wouldn't have done anything for her case. And they're going to go on to talk about, how bringing up the real estate would have, you know, given less credibility to Clayton, maybe, because, okay, they both lied about things. But as Bruce says, Laura lied about pregnancy and medical records, which is more relevant than Clayton not submitting offers in real estate. Yeah, because if this case was maybe surrounded by real estate and Clayton lying to her and many other people or something about this, and it's something he does all the time, then that real estate stuff would be more relevant in a case like that. But a real estate offer has nothing to do with the real estate in your body or your fake real estate that you have in your body. And so I do agree with Gingras. There was no reason for them to even cross-examine him. It wasn't going to do anything for them. He was not going to cooperate. He wasn't going to give them anything that would have done anything to help Owens. They couldn't. The only thing they have to discredit him is the real estate thing. They don't have anything else on him. And if that's all you got, it's not even worth it. And so, and Judge Mata knew about the real estate thing and that Owens says that Clayton lied about real estate. Mata knew about that. So even if he would have brought that up and tried to lessen his credibility at the evidence hearing, it still wouldn't have made a difference in this case because she already knew about it. And I don't think that Rachel here knows that Mata already knew about that, but she already did because it was in filings, especially after Owens tried to extort Clayton when she went rogue from her attorney. Let's see here. Denise says a lawyer is supposed to guide their client if they find out the case is not a good case, that it has merit. The lawyer is supposed to tell them no. Yeah, that's what ethical people would do, but some lawyers will just take a case no matter what and just take people's money. Bruce, uterus interest rates are too high. We need to help middle-class babies. They are high. Like, it is very expensive to rent uteruses and buy uteruses. They're very expensive. Definitely a depreciating asset. Because you've seen what the things that come out of the uterus are, and then they turn into teenagers. And sometimes it doesn't seem like a good investment. I'm just kidding. Kids are a great investment.
Yeah, go ahead.
It changes the finder of facts impression of the case, right? You put your client up there. You know she did poorly on the stand.
Sure.
Okay. And I mean, you also
he's like, no doubt. Yep.
She didn't talk a lot. You talked more. I mean, if you go back and you watch the trial, and I had the benefit of watching it after I already knew what happened because I didn't know anything about this case until a few months ago, way after the trial had happened. I had only seen a headline or two until Steve asked me to watch the trial. She came off very poorly. I don't know if you agree, disagree.
I have a detailed response to that, and I don't want to. And look, your opinion about how she testified is totally valid, Rachel. I mean, it was a tough day for Laura. I mean, it was an awful day. And what you don't know, and I think it's worth.
I don't care if it is a bad day for your client. It is your job as a lawyer to have her get up there and not be evasive. You should have prepared her, and I suspect that you did say, They're going to ask you about this. They're going to ask you about that. You just need to be honest, and say the things. And then his client went rogue on the stand with the Los Angeles stuff. Like she went off the rails. And then she wanted to start her emotional wreck thing. I don't care what caused it. There are criminal cases every day where victims have to get up there in front of somebody and testify against a person that tried to murder them or something. So, excuse me if I don't care why she came off bad. She came off bad because she is lying and she was spitting out new lies. Like, if she just would have gotten up there and said things like the truth, like, she wouldn't have had a problem. And that's the problem with lying so much, is you can't keep up with your lies. Or you have to find a new narrative when that lie has been revealed. The tough day is not what caused her to testify poorly. It's an excuse.
It's worth mentioning. And I don't know, I'm not trying to like titillate the JFC people who hate Laura so much, but I want to put you in my shoes
Nobody
a little bit
hates
from what I
Laura.
went through that morning. Because it was a morning unlike anything I've ever done in 24 years of doing this. Laura was, prior to the hearing, because of this issue of Maricini being there, she was,
which we will get to. That's the second thing I wanted to bring up.
she was as close to having a nervous breakdown as I've ever seen a client by a mile. And I actually was, at one point, Dr. Mitchell is a medical doctor who's done, he's an OBGYN, but he also did emergency room care. We were like having him look at her, like, is she medically able to continue? She was shaking, crying hysterically at the fact that Maricini was sitting there. And this is part of my story. Okay, you want to tell your story about...
There are no pictures or videos of her crying and having a breakdown. Nobody was like, oh my God, Laura's crying outside the courthouse, or she's crying on the bench outside, outside the courtroom. Like, she's shaking, she's crying. Like, nobody saw any of this. Do they forget when they're telling these stories that people were there and can fact check? There were cameras on them. There was recordings of them. And none of this was seen. So you're just lying.
Oh, well, Laura sent mean emails to Clayton or whatever. I need you to understand that no litigant should ever be put in a position where they fear for their safety. They have to stare a person in the face that they have a restraining order against. The guy sitting there laughing at her. And all of that
Nobody was laughing
because Judge Mata ignored the rules. And I'll be specific about what I'm referring to. She was required to set, they call it a pretrial conference, but it's a hearing before trial to talk about anything that needs to be talked about. And Judge Mata's minute entry order setting the hearing said, if anybody wants a pretrial conference, just ask for it. I asked for it the minute I found out that Maricini was going to come, after his lawyer lied to me and said he wasn't coming. Okay. I found out at the last minute, oh, he's going to be there.
He says his lawyer lied to him. I don't think Randy Sue Pollock lied to him. I think that she didn't know about any of this. And when he called her, she was like, I don't even know. Like, what are you talking about? Like, I haven't heard anything. And so I think she just didn't know anything at that time. I don't think she knowingly was like, oh, I'm going to tell him he's not coming, even though I know he's coming. You have no proof that she lied. But you just want to call her a liar. You can misspeak, but everybody else is a liar if they misspeak.
there. I said, look, we need to talk about how do we do this. There's a restraining order against him from California. Judge Mata had no authority to disregard it, which he did. All I wanted to do was talk about how can I keep Laura and Maricini away from each other so that she doesn't have this breakdown. And Judge Mata thumbed her nose at the rules, denied my request for a hearing, even though the rule said shall be set. Just said, no, I'm not going to. And she put Laura in a panic position. And I had to try to deal with that on the morning of trial.
Put anybody in a
you guys
panic
look like you're
position.
not happy with me saying this for some reason.
No, we just don't believe it. That's
say
why.
what you want. Steve, be honest with me.
You've done orders of protection before, right? And
Sure.
You've done them, of course.
Sure.
You know that the standard is the person has to confront in court the person they claim abuses them. They sit right across from each other.
Yeah, not
a very stressful event.
Not in an interstate. Maricini was not a party to this case. Okay.
But I'm not talking about whether it was legally appropriate. I'm talking about your client being so overwhelmed. You've never seen anything like that.
Mm-hmm.
You know, she was so stressed by being in the presence of Maricini. I would argue it's because her gig was about to be up. Because here's the guy that can prove that it's not the first time she's done it.
Her gig is up.
Disagree with me. People have had to sit next to people
because she's been lying all this time.
Beat them up in order to get a permanent order of protection against them.
Yeah. So and my response to that is that Laura already did that. She already jumped through those hoops. She already had that fight in San Francisco. And people.
She jumped through no hoops. She just wrote, "Hey, this happened," and people believed her because they didn't fight her on it. And it's also really easy to get these orders of protection or temporary orders, restraining orders and stuff. It should be more difficult to get them to be permanent. It's where I think Maricini did not have good representation. Because he was told just to let her have it. No. I don't think Maricini would have signed knowing that the implications it was going to have on his life. And if his attorney did not tell him, hey, don't fight it, it should just go away. But she should have told him that if it doesn't, this is going to be on your record and you might have trouble finding a job. And I just don't think he was well represented. And she hasn't proved
people
anything.
Again sort of misrepresent what happened. Maricini agreed to the restraining order initially. People he's a victim. He effing agreed to the restraining order. So I don't know how you label a victim of false allegation that you agreed to and didn't.
Just because he agreed to let her have the restraining order so that she would go away, he just wanted it over with, is my guess. It doesn't say that just because you're saying, oh, I agree to stay away from her is basically what you're agreeing to. It does not mean that he agrees with what she has said about him. It just means, yeah, I'm going to stay away from her. I don't want nothing to do with her. And he doesn't. And so he's like, well, you can't say false allegations and agree to it. Well, he didn't agree to the allegations. He just agreed to leave her alone, which he was doing. So he's arguing something that isn't even there. And then, as Bruce says, Gingras ignores Rachel about how you have to see the person you don't like in court. What you do, because you have a constitutional right to confront your accusers. It's in the Constitution. And so, and the thing is that just really gets me is she has something on all these men, right? So why is it Maricini that sets her off? Why isn't she this rattled about Greg too? If Greg is as bad as she says Greg is. Why isn't she this scared about Clayton if he arped her? That she has to see him and face him in court. and she's going to have a mental breakdown at the courthouse, but she was fine having a Zoom call or a telephonic call and speaking to them. That wouldn't have given her a mental breakdown. Because I tell you what, real victims, just hearing their voice and talking to them or seeing them would have put her in a mental breakdown. But she was going to be okay with talking to him. She wouldn't have lost it or had a panic attack then. But why was it just Maraschini that they went after? Because wouldn't have Greg been in violation of his as well? I mean, I get his was in Arizona, so it wasn't a cross state line thing. But I don't understand, other than the fact that Maraschini is the one that had the laptop with the forensics. Why was she not just as scared of Greg? It makes no sense.
And did not challenge. But then he violated the order and she got it renewed for 5 more years. Okay. All I'm saying to you is, Rachel, you're not wrong about, sometimes people have to go through difficult things, but I think what you're doing is disregarding the fact there were 20 difficult things happening that morning. And to have this guy be there that had no grounds to be there at all, it just broke her. Okay. So all I'm telling you is the morning was not a good morning. And I think there were justifiable reasons for it. And my conduct that morning, I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd.
So
that is not how lawyers should be, or litigants should be made to feel. Everyone should feel like we're going to have a nice day in court. Everyone's going to be treated respectfully. It was a circus. It was a circus. And it was a circus because
what person going to court is like, this is a nice day. Everybody's going to be respectful. Have you ever watched hearings and trials? Like, nobody is in there having a nice day if they have to testify, or they're facing their accusers, or they're victims of somebody, or their family's in there and it's a murder case, or somebody that robbed them or did other things. Like, nobody is going to court saying it's supposed to be a nice day. Like, everything is just going to be fine and great and sunshine and rainbows. That is not how courts go. That's not how family law and divorce works either. It's contentious.
Because Mata had her father sitting there, and I assume that her sister was watching as well, because the sister follows her on Instagram, Clayton on Instagram. That's how it felt to me, Rachel. I'm just explaining to you how it felt, and I don't know. I can never put myself inside Judge Mata's head. I don't know what her reasons were. I'm telling you how it looked and felt to me and Laura. And Laura was that morning, before we even started, she said to me, I don't know if I can go through with this. I just don't. She saw Maraschini in the parking lot and she
can't go through with it because she's out. Lying.
So I did the best that I could,
and now
to try to put the pieces together to keep it from falling apart. And I didn't do very well, but
wouldn't that be a better reason if you thought Laura was going to be even worse on the stand because of her mental, because of her state of mind? Wouldn't that even be more of a reason to devote more of your time to cross-examining Clayton rather than putting her up on the stand to dig her a deeper hole? Because at the end of the day,
I don't agree with Rachel there. I don't think that he should have
significant discretion. It really is, especially when you're talking about findings of reasonableness and unreasonableness in litigation.
It was about her story.
When you see a litigant out there who looks like they're lying, who looks like they're up to no good, it's not going to help the background of your case. And I think if you had been able to show that Clayton also lied, as you claim you could have, and I'm not saying he did, but if you had been able to undermine his credibility, this might have looked more like black hat, rather than white.
It wouldn't have, because Judge Mata already knew about it.
I really mean this very respectfully. That sounds like a TV show that you just described, not a real courtroom situation. I mean, I'm not denigrating the hot bench thing. I've never seen it. Okay, but what you're saying is right. If you're talking about, let's make this a movie or a TV show, make it dramatic. Laura withdrew her petition 6 months before the trial.
We didn't have to make it dramatic.
6 months before the trial, Laura said, "I'm not pregnant anymore."
She made it into a TV show.
These were on the table. They were put
to that point. Let's read here. This is so good. I really am glad that we're having this discussion. It's ARS 25809G. Okay. And the judge in the Court of Appeals quoted this. This is so good. Here's the part that you're just like not taking this into consideration.
Is this the maintaining or defending the proceeding language?
Yes. Maintaining or
part of the proceeding was his request for attorney's fees set forth in the response to his petition.
So you're saying
not get to decide the entirety of the issues that will be presented by framing her petition. You have a response. Clayton asserted a claim for fees.
A claim for fees for the petition, not for going to San Francisco and investigating Maricini's laptop to make some determination about what happened 8 years ago.
The reason that even got put into this case is because it was said that she has doctored medical evidence before. And then you filed something that said Owens says she has never doctored anything like that. She's never had cancer. She didn't have her ovaries removed or anything like that. You made that part relevant when she lied about it and said that she hadn't done that before. Because if she would have not said anything, like she wouldn't have disputed it, or if she would have been like, yeah, I did at that time, which, that just makes her look more guilty. But because you disputed it and you said, Laura never did this, so y'all are acting like this is the first time when she doctored the HCG results and the sonograms, that this is the first time she's done it, and those past things that people are saying she did aren't true. Well, now we have to go back and disprove that. We need to prove that once again, she is lying. So you made it relevant. That's how it got brought into the case, is because she denied it. You put that in a filing because you believe everything Laura says. So that's how it became a part of this case.
That is not maintaining or defending a paternity petition, a withdrawn paternity petition. That's Rachel, I respect your position. I respectfully.
It's about credibility, and proving one's credibility or discrediting one's credibility is a huge part of civil cases and family court cases. You want to discredit them. You want to prove that the other person is a liar. You can't believe them. They're bad. I'm good. And so credibility is a central part of a case, whether he wants to think so or not. It is huge. Watch any civil case, and credibility is one of the main things that is happening there. And so when your client lacks credibility, it's a huge factor.
Respectfully disagree with it. And yeah, I get that the Court of Appeals is on that other side. I lost that point. I couldn't disagree more with it. You cannot, Arizona has such a narrow view of when attorney's fees are awardable. They have to be specifically permitted by statute. And the statute says maintaining or defending the proceeding, the paternity proceeding, which was moot by then. Let me rephrase.
The only thing
In
in the proceeding. There were three things in the proceeding.
It's a proceeding, not a petition. It's a proceeding. The entirety of the thing, including his affirmative request for relief.
That the family court had no jurisdiction over. The family court in Arizona is not an unlimited jurisdiction court. It is a limited jurisdiction court. It's like small claims court.
She invoked the jurisdiction of the court when she filed the petition. She doesn't get to divest the court of jurisdiction by saying I'm not pregnant anymore.
Or she invoked the court's jurisdiction for the purpose of deciding paternity, which ended December 28th. There was no paternity to decide.
Okay. But that's like saying that if somebody files a counterclaim, the minute that someone files their claim, you're just wrong.
No.
Invoked the jurisdiction of the court.
And here's
for the petition.
Right.
Okay.
And
but then Clayton properly invoked the jurisdiction of the court on his request for fees in response thereto. He does not divest the court of jurisdiction. Show me a case that says that when she's no longer pregnant, he can't follow up on his response.
It's not that the court didn't have jurisdiction to decide fees. It's that it's the question is what fees? Fees for what? Clayton absolutely could have applied for fees incurred if he could prove that they were reasonable between December 12th and December 28th. That was the time that the petition was still pending. And his request for fees to amend his answer to seek fees hadn't even been granted by the time that Laura moved to dismiss. But let me rephrase it this way. Here's how I see it. And you tell me why this is wrong. I read 25809G as saying, I'll paraphrase it, A party can receive attorney's fees for the money that they spent obtaining resolution of the petition.
That's wrong, because it completely dismisses the concept of counterclaims, the concept of affirmative relief being requested in response.
Clayton, the Superior Court has no jurisdiction over anything other than Title 25 issues. And this issue with Lorelei about Maricini's cancer records or whatever is not a Title 25 issue.
It goes to her credibility. And if she is not credible, that is a problem for her. And you're allowed to prove things that are not credible, that are relevant to the case. And when your client says in a document, in this case, that Maricini is a liar and he doctored those and he did that, not her, you made it relevant in this case. And so now we get to disprove her credibility on something that she's lying about. But this is where I'm saying I finally get what his mind is saying, that he doesn't think about the whole case. He thinks that this case is only about the paternity. And so let's go through things that involve that. One is going to be her credibility. So you can decredit her as long as it's relevant to prove that this is why I don't believe her. So yeah, he spent money there. He had to spend money even if the pregnancy ended in December. It wasn't till later that she signed the HIPAA forms. So if he's saying that he can't collect on things when the HIPAA form was signed, which relates to that time period before December 28th, as he's saying, for his attorneys to do all that work to find out if she went to these doctors during that time period she was pregnant, to prove, one, there's pregnancy, also to prove that he's the father, because, well, you can't be a father if there's no babies. So even work that they did after December 28th was still relevant to that time period between May 20th and December 28th. Everything they did had to do with proving of the paternity and whether he was or was not the father, because it also had to do with whether she was or wasn't pregnant. So even if you take the Maricini fees off, okay? Like, whatever, take that off. Like, she's still going to have a chunk of change. So I can just agree with Gingras here. If we take all the Maricini stuff off there, deduct those fees, everything else had to do with proving whether she was or was not pregnant and whether Clayton was or was not the father. So even if they went back and did that, doing a deposition, which was well after December 28th, still goes to proving she was or wasn't pregnant with his kid. The HIPAA forms and trying to find all these doctors and get those records, trying to contact Planned Parenthood, which led them nowhere. So then they're like, okay, well, what now? Because we still don't have anything. And trying to still get the truth out of her, and then find out at the hearing on June 10th that we should have been looking at Los Angeles, which they wouldn't have found anything there either. But like, she's still doing things. And so this is where I don't agree with him that anything that was done in this case after December 28th, he should not get fees on, because it was still all pertaining to that time period between May and December 28th. So I understand what he is saying. I don't agree with what he's saying.
The issue. Clayton did what it's so simple to me, and I don't know why we're butting heads on this. Clayton did not need, if the issue is how much did it cost him to defeat the petition, the answer is not $150,000.
If what you're saying is how much did it cost him to just not have to have paternity established against him, right. I agree with that. He didn't have to proceed, and I completely agree with that. He didn't have to proceed with his request for fees. He could have just gone away and it could have all been over. I agree with you there.
So
but he wasn't obligated to do that.
Yeah, but what you're saying is that somehow there's this magical right to assert a counterclaim for fees and then spend an unlimited amount of money investigating any unrelated things that you want to try to show that Laura filed the thing in bad faith. I just don't. Don't you
think the fact that she's done this before and faked pregnancies before would tend to suggest that she didn't have a good faith belief that she was pregnant? To me, that's very relevant.
So here's where I talked to Steve about this before, and here's where I
David,
feel
real
like
quick, David, real quick, can you move to your left to center yourself more? Yeah, because you're kind of going there.
I'm kind of, I'll just turn the camera.
Yeah, there.
Appreciate the direction there.
Yeah,
Steve in the mirror.
This is what Steve and I talked about before, and I think where I really disagree with you is I see the paternity petition as I see the paternity action as a small little box unto itself, and the only issue there is paternity and fees related to paternity. Okay, that's how I see it. What I hear you saying, and where I think I disagree, is you see a much bigger legal dispute that needs to be resolved. Does she have a pattern of doing this? Was there emotional distress that Clayton went through? Did Laura defame Clayton? I agree with anybody that says that those are important issues. They're important issues. They're just not issues for the family court. They're just not issues for the family court. They're issues.
That issue needed to be resolved, but I think saying that you are going to artificially narrow this to only the question of paternity, that it's a deliberately dense reading of the maintaining or defending procedure.
Okay.
I can say if he just got awarded fees on proving paternity, because even if you're not pregnant anymore, you can still prove, like if she was pregnant, she would have been able to prove paternity with those Rabgen tests that happened before December 28th. Because there were no Rabgen tests after December 28th. So if we want to go by what he's saying, is that Clayton should not receive fees for anything other than trying to prove paternity, we can say, okay, you can be right. But where I don't agree is that the fees stopped on December 28th. Just because she wasn't pregnant. Because you still have work to do to prove that she wasn't even pregnant. So there was no paternity to actually be established, and that she filed it in bad faith. He gets fees on that. It's not like, oh, no babies are here, so you can't even investigate pregnancy anymore from the time period she was even pregnant. None of that stuff even mattered. Well, it did, because if you filed it in bad faith, that's a problem. And Clayton gets to prove that she filed this in bad faith. And her losing babies or whatever, he still has the right to say, this is frivolous. So I don't think that was the only thing on the thing, is he had the right to prove that she was lying. And because she lied, she has to pay for this lawsuit because she knew she was lying. You wasted everybody's time and money. Now you need to pay for the whole thing. Your whole show and shenanigans. You get to pay for it all. Congratulations. You could have just saved yourself a ton of money by telling the truth.
Okay, let me flip this around for a minute. Let me flip this around. You know that during the case that Laura said that Clayton had non-consensual intercourse with her, that he asked her to stick it in. She said, no, you can't. And he did. Okay. You understand.
We don't know that. We don't know that he did. We weren't there.
At some point she said that is all.
Okay, hang on. Wait, just hang on. Yeah. I'm not saying
Always
that
has to put
happened.
this
I'm
in
saying
there.
that was an allegation. Okay.
Yeah.
I wasn't there either. I don't have any idea.
Yeah.
But under your reading of 25809G, because Laura made that claim, are you saying that it would have been appropriate? Can I finish? Are you saying it would have been appropriate? It would have been appropriate for Laura to say, I now need to interview every female who was on The Bachelor and depose them to find out, did Clayton rape them too? Do you think that fits within the family court's jurisdiction?
Of course not.
If that was true, I'm not going to say that is true, but because I don't believe it. But if somebody from the Bachelor franchise or anybody that any of Clayton's exes from the past period came forward after hearing about Owen's story and what Clayton supposedly did to her, and somebody came forward and was like, I feel for you because he did that to me too. Would Laura then have the right to depose or get evidence of that? Yes. Not everybody, nobody, if you don't get to just everybody who has said nothing. Like, no, you don't get to, if there were people on The Bachelor that had come forward and said, I had the same experience, then she could bring that into the case. But you can't just, anybody he's ever met, been like, did he do this to you? Did he do this to you? Can't do that. If they were to come forward and allege the same things, then she could absolutely bring that up to discredit him. And it would make her case stronger. But none of that happened. There was no Me Too in this. Yeah, it was a different thing because, and also, and I will agree, just because even if Clayton had done something on The Bachelor, just because he did something on The Bachelor doesn't mean that he did it with her. Just because, even if somebody would have been like, yeah, Clayton's the father from The Bachelor, and they actually had a baby, and it ended up not being Clayton's, like, that still doesn't have relevance to this case. And the thing is it is not, I mean, it can show, Maricini and Gillespie can show a pattern. But the thing is that brings them into this, to me, is not that because she did it to Greg, she's doing it to Clayton. It's one that the stories are basically the same. But also that she denies lying there. Just like she denied the cancer and ovary removal and all that. Once you deny something and you say it isn't true, if it is true, it becomes relevant because now we're disproving what you said. We're impeaching you. It isn't because you did something to Maricini and you did something to Greg that means that you did it to Clayton too. It's the fact that you're doing the same exact things. And it didn't happen necessarily fully in the exact same way, but there are so many similarities. And you're saying that they are liars, that they are this. So it gets brought into this case. But the fact that he goes back to The Bachelor, should we be able? No. If somebody came forward, it would be a different story. But you can't just go asking people.
Of course not. How is it how is your argument any different?
Well, because Laura came to court and said, I'm pregnant. We now know she's done this several times before and hasn't been pregnant. It appears. Okay. If the issue is a good faith basis for believing she's pregnant,
she's been pregnant all these times.
Faked pregnancies would certainly be at a minimum relevant. You know how low the bar is for relevancy.
I'm going to challenge you on that. I'm going to challenge you on that. I'm going to throw out another hypothetical. This is exactly the kind of debate that I have with a lot of other people. So hear me out. Hear me out. I'm going to hear you out. Hear me out.
Pretty much.
Let's assume. Let's entertain a hypothetical for me.
Except for minus.
Assume for the sake of argument that Laura was pregnant with Clayton's child. Just assume that fact is true. Okay. If Laura was in fact pregnant with Clayton's child, would the fact that she sent fake cancer records to Mike Maricini 8 years earlier change the fact that Laura was pregnant with Clayton's child?
No.
So and if Laura was not pregnant with Clayton's child and she didn't send these records to Maricini, would that be relevant? But
no, wait, hold on. But you're asking, would it change whether or not she was pregnant? No, but it would change whether or not she had a good faith reason to believe she was pregnant when all of a sudden she was no longer pregnant anymore.
Okay,
hold on.
It became relevant because, like she denies doctoring other things, she is denying doctoring those things. When Clayton says she has doctored medical evidence before, and she says, no, I haven't. Well, yes, you have, and we can prove it. So it has nothing to do. It had nothing to do with because she said she had cancer to Mike Maricini. It was the way it became relevant was the fact that she said she hadn't doctored anything before. And we have proof that she has doctored stuff before. That's how it became relevant. It has nothing to do with the pregnancy. It has to do with the doctoring of images that she submitted in this pregnancy case. That's where the relevance is.
Hold on, you gotta hear me out. The fact that she has a history of appearing to claim. Have you read her communications with Gillespie and Maricini?
I've not.
Okay.
I've read some of
the worst of the worst.
Huge problem, right? In debating this issue. I'm not saying you can't successfully represent her on appeal without reading that.
Sexual assault.
But in terms of this conversation, I mean,
the three biggest no-nos for me in lying is lying about cancer, lying about pregnancy, and lying about sexual assault. And this woman has done it all. She has lied about cancer. She has lied about pregnancy, and she has lied about being sexually assaulted. My top 3 things that you should never lie about. Because those lies affect other people. It's not like, no, I didn't go to McDonald's and eat the McDonald's in my car so that didn't have to get my kids McDonald's and tell them, no, I didn't eat anything. It's not like that. Like that lie didn't hurt anybody except for my kids' feelings, maybe. But it didn't change anybody's life. Her lies change other people's lives. And they're just the most despicable things to lie about. And you are a vile human if you can lie about those things. And then you double down on them. You won't admit to them. And you will not seek help to make yourself a better person because you lied about that stuff. It takes a horrible person to lie about that stuff. I don't even like the April Fool's I'm pregnant jokes. Those jokes piss me off. Oh, God. What did I do? Okay.
From just taking Maricini alone, she claimed to be pregnant for months after having multiple abortions, according to the documents.
Well, okay, so this is where
That is so ridiculous. Certainly tends to suggest, bar for relevance is very low, you know that she was not actually pregnant and didn't believe she was pregnant.
Okay, couple of things. This is one of those issues where I don't want to get into a debate over evidence I've never seen. Do I have a document that says it's text messages? Yes. Was I ever provided with the original laptop? Absolutely required by the disclosure rules? Nope. Was never given that. And I've never seen that evidence. And Rachel, I don't know if you're aware of this.
They aren't required to hand over the laptop. The only thing they're required to hand over is the information from the laptop that they have, that they will be using. That's it. They don't have to physically give you the laptop. That's nowhere in the law does it say that. You just have to provide the other side with the same information, which they did. Maybe it shouldn't have been in an edited format, okay? But he doesn't have a right to touch that laptop. He just has the right to have the information that was gathered from that laptop.
PDF that wouldn't disclose to me was totally insecure, such that you could go in and change the wording on any line you wanted. And I did. I used an example. I went in and just typed some crap and saved the file. So I'm not saying, and Maricini actually filed a bar complaint against me where he said I accused him of fraud because I raised that possibility that somebody might have tampered with his PDF. I never said that he did. I don't know. I never had a chance to investigate that, is all I'm saying. So you're sitting here telling me, well, Laura said this in these messages. You have no idea if those messages are real or not. At all. You don't. You think they are, but you don't know. You don't know. And here's ultimately why I'm so strongly disagreeing with you. You clearly believe that witness credibility is relevant in a paternity case. And what I'm saying to you is, there is no situation in which a woman could win or lose a paternity case based solely on her testimony, ever.
What do you mean win or lose a paternity case based solely on her testimony? What do you mean by that?
A paternity establishment petition cannot be adjudicated based solely on the testimony of the mom saying, I think I'm pregnant. You agree with me? Yeah.
Absolutely. Okay. However, many issues in a paternity proceeding can turn significantly on credibility, including the parenting time request that your client asked for.
The credibility.
That
if you have someone
the court never ruled on. The parenting time that never became an issue because there was no baby to have a parent.
And the reasonableness.
I'm glad he says there's no baby because there was no baby.
When it comes to attorney's fees.
Okay. Anyway, maybe we should move on from this topic because you and I are clearly not going to agree on this. The way I see it, Rachel, is there has to be a causal link between the person's bad conduct and the fees that you're claiming that you're looking for.
Do you have case law on that?
Oh, of course.
That there has to be
I will say
when you're
there's
talking
a
about family law
causal link
sanctions,
to
because in
all of
California
it.
it's not the case. You do not have to establish a
I would
causal
like
link
to
You
for
just-
him to tell me
and unreasonable
how
conduct.
my
They have to
theory
be related
is
in the sense
not
of I can't go out and spend
true.
fees investigating a separate tort claim against another person. But you do not have to establish that the unreasonable conduct caused specific fees.
I will get back to you on case law for that. Okay. Can we move on to the topics? Steve, you're the moderator here.
Yeah. I mean, we're going to have to somehow tighten this up because we just spent 38 minutes on the first question, which was, why didn't you cross-examine Clayton? Now, we did get into other stuff that we were going to hit on later, which was,
Maricini. You were going to ask me about Maricini.
The takeaway, hold on. So the takeaway from that is not that it was a deliberate decision. It was, you had to kind of like figure it out on the fly, and you kind of made a call on the fly, right? That it would be more important to use your time with Laura.
I did not believe and do not believe that Clayton's testimony had anything to do with anything that I needed to prove or disprove. I didn't see the value in it.
I wish we could have gotten that in 5 minutes. Instead, it was almost feel like we're at the trial because we just spent 40 minutes when we're on somewhat of a time crunch. But I mean,
all right, let's move on.
Stuff up. All right, let's just get to the Maricini stuff.
Talking about Owens didn't do anything for his case either.
You explain the story of everybody is very well aware that you called the Arizona Police Department to have him taken away, arrested for showing up to a trial that he was subpoenaed to be a witness to. Go. Yeah,
he was not subpoenaed. First of all, he was not. Arizona subpoena is not valid to compel a witness to appear from California. Rachel, you disagree?
He was served with a subpoena.
From California? From California?
Hold on. You say he wasn't subpoenaed, okay?
Not a valid subpoena.
He was not served with a subpoena that could have been enforced, is what you're saying.
Correct.
So this is something, because I'm not a lawyer, that I don't understand. Like, so if somebody gets a subpoena from another state, and so Arizona sends a subpoena to Maricini in California. Then he's saying that California should have sent a subpoena as well to Maricini, telling him you have to go to Arizona. Why does he need a subpoena from Arizona and from California? Because he's like, did he get one from California? Why does California need to send him a subpoena? So I would like to understand that and what he's trying to say. Maybe Omar knows. Because even if he's wrong, I would still like to understand what he's talking about when he's saying it wasn't valid. Is it because Arizona didn't call California and say, hey, can we send this subpoena? Do we have your permission to subpoena him? And the court has to sign off on that subpoena and then they send it out from there. Like, I would like to understand what he's talking about here. Because I don't get it.
Declined to appear.
Correct.
I understand that you're saying that's
So-
what you're saying. It's cross state line.
So here, this was part of Mauda's bar complaint against me, Steve. I assume that you're very familiar with that. And she said, well, she said, I forget the wording of it, but she said something like, I'm not going to find witness tampering, but it looked like, what did she say? Do you remember what she said specifically?
I don't remember the wording of it. No.
So
You were
witness
using
tampering, you
hand
can't like
rules.
threaten a person and say, oh, if you come to trial, I'll burn your house down. I mean, that's, you can't, it's witness intimidation. Can't do that. So what happened behind the scenes, and I assume that you guys are familiar with these facts by now, that
We've
I get
seen the
with
emails that you
bare bones
threatened
disclosure
to
statement
have
where he
him
says
arrested.
Maricini's a witness and he's going to say something about something, which is a violation of our disclosure rules. You have to list a fair summary of what the witness is going to say. Wouldn't gave me no details at all. So I find this out and I pick up the phone.
You had details because Maricini told you the details in an email. You knew what he was going to say. Because we knew what he was going to say because it was written out. He was going to testify about Laura lying that she was pregnant with a kid from him and that she also decided to get some type of order of protection or order against harassment or a restraining order against him when they didn't want to be with her. So you knew, and about the laptop. So to sit here and say that you didn't know anything about anything and nobody told you is just a lie. And we've seen it in black and white. So stop trying to sell this story because nobody's buying it because we've seen it.
Phone. I call the only person listed as a contact for Maricini is his lawyer in California. And she goes, I don't know who you are. Maricini's not coming to trial. He's never heard of this case. We have nothing to say to you. I said, great. Can you send me something in writing to confirm that? And she did. Miss Randy Sue Pollock. Okay. So she sends me an email. She says, he's not coming. Great. I just scratched that off the list. I then, days before the discovery cutoff, get this 2,500 page text message drop from Woodnick saying, oh, Maricini is going to come to trial and talk about these 2,500 text messages that you've never seen before, 2,500 pages of text messages. I immediately then tried to figure out, I went back to Randy Sue Pollock, said, is he coming? She said, we're not going to talk to you, which is not okay under what Rachel, what's the eyebrow?
You think that he has an obligation to talk to you?
Absolutely. Discovery was still open. Discovery was still.
So you had the right to depose him.
Absolutely.
He doesn't have an obligation to voluntarily be interviewed. You could have.
Which is
it's like absolutely basic law. You don't have the right to have a third party witness submit to an interview. You can depose them.
Wow. Stop.
Yeah.
That is exactly the conversation that I had with Randy Sue Pollock. What I said was, I need to depose him, or he can talk to me. You can choose to be voluntarily interviewed if you don't want to be deposed. I was willing to do whatever was easiest. She said, you're doing neither. She said, we are not letting you talk to Mike. Okay. That's not okay. And more importantly,
you don't have to talk to the witness. You can talk to their attorney. And you know what? You ended up talking to him through email. It might not have been the way you like, but you had communication with him. And so maybe at the time when he's trying to have all that, maybe this is what he's feeling like. But nobody said you can't have either. Like, nobody's going to tell you anything. We're just going to put this name on the list and you can just get a surprise. That's not what happened. He knew what was going on and he's just trying to play dumb. I don't even want to listen to him talk about this bullshit.
So look, I never said the guy can't testify. I just said he can't be within 300 feet of Laura. So
how is he
going to testify if he can't be within 300 feet?
Let Laura leave the room. Let him be in a different room. Let him.
Why couldn't you just ask the judge to let her leave?
When did I get a chance to do any of that?
I'm asking you.
That is, well, if you go back and look at what I made an opening statement.
He talks about he never had a chance to separate the two of them and make it to where the 300 feet could be adhered to. Didn't the judge say that if you wanted them to not be in the courtroom, that I was going to cut some of your time out? Because she was going to be counting the minutes and stuff. I said, if you go back and watch David V Echard, she had a clock on those attorneys. Like, this isn't something new. Because they don't want things to continue to go on. He had the opportunity for his client's mental stability and for her safety, if that's what it was really about, to have Maricini not be in the courtroom until he was going to testify. They could have done that. And he's like, oh, it would have taken away time. And it actually wouldn't have, because they didn't end up having time for him anyways. But for him to be like, when did I have the chance to have them 300 feet apart? In the beginning, when you decided, no, everybody can just stay in the courtroom, y'all decided to forego that. So you had the chance to have him more than 300 feet from Owens. But you decided against it. So you can't cry and say, woe is me, and then not take the opportunity to do it, because you had the opportunity to protect your so-called client and you didn't take it. So you don't get to cry about it now.
To the court at the beginning of the trial, raising these exact issues, and Mata just didn't want to entertain any of it. Okay, if she had given me options, I would have considered them. We just didn't. We did the best we could with what we had.
Gave you the options.
Asking the police to enforce a valid court order to me is a not controversial thing. I mean, I just should have ignored it. I just should have said, sorry, Laura, California court orders don't apply in Arizona, even though there's a federal law that says they do. I don't know what you
should have said that. But I think you might have said to your client, we're not going to call the police on him when he's here to testify. And we've known for months that or weeks, I don't know what it is, that he's coming to testify.
Days.
And that's it was days. Okay,
yes.
So she should have been prepped that he would be there and not have the police called when he came in.
Okay, I just agree to disagree. There's nothing. Anyway, we'll just see it. We see that differently. And again, Mata did what she did, and so far nobody cares about my arguments. That's not really part of our appeal. I understand it's part of the bigger picture.
Because she gave you the
option.
Just
as a layperson, we did have security officers there. We did have police officers. What did you think was going to happen? What did she think was going to happen? He was going to jump over benches and attack her? Steve, let's just be honest here.
Steve, first of all, you're asking a question that should be answered by Laura, not by me. But all I can say about that is she had a court order that said this man is not allowed to be this close to her. Why did she want the court order enforced?
Don't have him in the courtroom.
Why should she have to give up her rights? Because
keep him in the room.
We just don't like her very much. It's anyway. I don't agree at all with what you guys are saying, and you don't agree with what I'm saying.
He had opportunities.
I just didn't want Maricini to be there and intimidate Laura and scare her just by looking at her. I don't care, Steve. If it was just bringing back bad memories, okay? Laura should not have to suffer through that just because Clayton was on a TV show. Okay, that doesn't give him some superior right to make Laura feel the way that she felt.
Nobody's claiming that it does.
Really?
Yes, really.
Okay. All right. We're moving on to the next question.
Because if she actually had real fear and it was a real situation, exactly. If that made her feel that way, but you had the opportunity to keep Maricini out of the courtroom, at least until he was testifying. And you chose not to do that. So why would you not, for the sake of your client, make him sit outside the courtroom? You can't have it both ways.
we're not gonna get very far with that. So
okay, so I guess we'll move on from the trial. We know what the trial's decision was, and then obviously we'll just get to the most recent thing, which was the Court of Appeals denial, and you lost, and you kept your streak alive of losing in this case.
Which, by the way, there was 0% chance.
0% chance. No chance in hell that Clayton was going to win this appeal.
What lawyer ever says that? If they're being,
I don't. Did I say 0%?
Yes, I played the clip. That's what I tweeted out. I have the clip.
Well, you're welcome that I gave you that. That's such an easy way to roast me.
Yeah.
Guys, look.
Yeah.
But
why did you say it when you? My problem was
I believed it. Because
I have no problem with you believing your client was going to win.
Or I think I'm going to win.
It's the presentation of it when you made it seem like there was 0% chance when you've been in many litigations. It's a possibility you might not win something. I know you're projecting confidence in winning, but it just it came across horrible, and then we ended up being right.
Guarantee your clients
that makes it that much sweeter at this point. But it ain't over yet, Steve. It ain't over yet. We may still get a 100% victory for Laura. We don't know. So I actually could be right. Actually, could wind up being right. We just don't know yet.
We're talking about the appeal.
No chance you lost.
And then call people names.
Yeah.
And that appeal has been lost. Right now, you elevate it. Obviously, something could change. I would never say there is a 0% chance that you will have this.
Rachel, here, can I offer you like a cookie or something? What do you want me to say? What do you want me to say?
Not saying 0%. Just say you're confident in our case. We like our case. We've made a strong argument. I really like my appeal. And I think we have a good chance to win this thing. But to degrade everybody who says you're going to lose and everybody who says who ended up all being right, to just do it the way you did it. I'm just saying you could have taken a more tactful approach. You don't agree with that? I
hear what you're saying. Steve, we're living in weird times, man. I've been drinking too much Trump Kool-Aid, which again, I don't like Donald Trump. This is sarcasm. Does Donald Trump ever say, "Oh, I'm going to lose the election, or I'm going to lose this criminal case"?
Why are you obsessed with everybody you don't like?
Don't like him.
That is part of the sort of trend of society that I think a lot of us are not happy with where it's going, right? That instead of having reasonable conversations, saying, "I'm really confident in this appeal, I feel like we're going to win it," we're taking the Trumpian approach and saying 100% victory. I mean, that's why the world is going where it is. Why contribute to that?
I give you my unconditional apology for using bombastic language that was just too confident. I shouldn't have said that. Can we move on? Okay. Yeah. It's not really what we're here to talk about. I don't think.
Yeah. Okay. So the Court of Appeals denial. So now we just
safe harbor.
She wasn't entitled to a safe harbor.
This
is being sanctioned under 25, I don't know, 809, I'm forgetting the number now, G, right? There is no safe harbor under the statutes that both Judge Mata and the Court of Appeals agreed she was sanctioned or Clayton was awarded fees under.
Okay, but do you agree with me? Do you admit that in Woodnick's first filing, he asked the court to grant Rule 26 sanctions? Do you agree with me with that?
I agree. At some point, he asked for Rule 26 sanctions.
It was in the very first thing. I don't mind telling you, I have that part memorized.
Okay. Yeah, I don't have any to agree or disagree.
And do you agree with me that?
Well, wait a minute, hold on. But fees have been requested prior to that by Clayton in his response to the petition.
In the same thing, he requested sanctions and fees.
Clayton's handwritten response.
Yeah.
Well, he didn't have any fees.
But there had been.
But he can say that Woodnick's first filing talked about Rule 26 fees. But before Woodnick was even on the case and Clayton was pro se, Clayton requested attorney's fees before Woodnick was even on the case. So to act like those fees don't matter is ridiculous. And he says, oh, he doesn't have any fees. He doesn't have any fees for this time period. Yes, he does. And he wants to say when she dropped the lawsuit. The thing is she didn't try to drop the lawsuit because she was told if she doesn't, she's going to be sanctioned. She supposedly dropped the lawsuit because she was no longer pregnant. I mean, so happened to fall within and around that safe harbor time period. It was actually after the safe harbor, but because she dropped it. We've gone over Rule 26. I have a whole video on it, but I don't agree with him on any of this. So Let's see.
A request for fees pursuant to the alternative statutes prior to any Rule 26 motion being filed.
Which he didn't incur, but yes, I agree with that.
Okay, so it wasn't, Rule 26 was not
You
the first
don't get to
time
determine
that
what
any of
he
these
incurred and what
statutes
he
were
didn't
invoked.
Yeah,
incur.
okay, hang on. You're getting a far afield here. You need to follow me.
I'm following you.
There was a threat for sanctions under Rule 26. You agree with me?
Yes.
Yes, there was. Of course there was. And that threat was in fact followed through on. There was a motion for sanctions filed, correct?
Well, when you say the threat was followed through on, yes, a motion for sanctions was filed and then withdrawn. I agree.
When was that withdrawn?
You tell me. February, January? When was it withdrawn?
April. I think it was April.
April. Okay.
I didn't get hired until March 25th.
Okay.
Okay. So it was months later that Woodnick finally withdrew this. The issue that you are missing, and I just totally reject where you're coming from. I'm sorry. I respectfully do. There was a threat of Rule 26 sanctions that invoked the procedure of the rule, and the filing of the motion invoked the procedure of the rule. Laura had a right to withdraw the offending pleading. She was not given that right. If she withdrew the offending pleading, what are we litigating?
What about the other bases for sanctions?
Okay. I don't know what part of this you're missing. Under Rule 26, if a person
Which
accuses
you're
you of
missing.
filing a pleading that offends the rule, you have a right to fix it. Do you
Before
understand?
sanctions can be awarded under that statute.
Under any statute.
But show me a case that says that, because your cases don't. I've read them all now.
No, you need to read them again. You're incorrect. You're in
Can you
courts.
just cite me? Just give me a quote from Holgate. Just give me a quote from Holgate that says
Do you want me to have like a break and come back to this? I'll be happy.
Yeah, if she wants a quote and you can get one, yeah, let's just.
Permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. What they are saying is you can't do an end run around the safe harbor by using some other way of getting to the same place. You have
no,
to.
that's not what they're saying.
I
What they're
totally.
saying
What are they saying?
What they're saying is the court cannot say, you know what? Instead of calling this a Rule 11 motion filed by you, we're going to call it a Rule 11 motion that I initiated sua sponte.
Correct.
Right? Which is completely different than what happened in this case. Because there were other proper requests for sanctions under different authority than Rule 26.
Okay. All I'm saying to you is, Rachel,
What's your response to what she just
what
said?
is your response to that?
you are ignoring you are pretending. Wait. If you want me to stay on this, you need to let me have fair opportunity to answer. Okay.
David, of 58 minutes, you probably talked for
Right.
42 of them.
What have
Come
we
on, man.
Okay, guys. Rachel, the problem is you are pretending that a Rule 26 threat was never made, and you are pretending that a Rule 26 motion was never filed. You are
Nobody is pretending that Rule 26 didn't ever exist. We are saying that it was not in existence at the end of this case. And the thing is where I understand where he is coming from now. Once again, I do not agree, but I understand what his line of thinking is. And the thing is if MATA had ruled sanctions or attorney's fees under Rule 11 or Rule 26 and said, you get this $150,000 because of Rule 26. I'm awarding this under Rule 26 or Rule 11, Title 25, whatever. Then it would be reversed. But she didn't rule under those authorities. She ruled under other authorities, and she's allowed to. So he would have a valid argument if she had ruled based on Rule 26, but she didn't. So his argument is meaningless.
ignoring those facts, and you cannot do that because
I'm not. I'm just saying that sanctions were never awarded under Rule 26.
brilliant,
They were awarded under different statutes
brilliant. But are we going to pretend the Rule 26 threat didn't happen?
in August and December under different authority. But that wouldn't be the case if you really believed that Rule 11/26 provided a safe harbor against any sanctions related to the filing of a frivolous, not frivolous, but the improper filing of a pleading.
Because I wouldn't call it sanctions. What I'm saying to you is, my view of the law is, if Laura engaged in sanctionable conduct, a violation of Rule 26, we address that under Rule 26, right?
No, Wait, we addressed that? What do you mean? You didn't address it. Was not addressed under
Hang on. That is the legal argument that I made in the second part of my opening brief that you said was after Rainbow, the next section where I said that she was protected under for the safe harbor applied to relief under other authority. And what I was saying is, if you read the arguments that I made there, there's a general rule in Arizona that when a statute provides a remedy for a wrong, that remedy is exclusive. Okay, so you can't say you violated Rule 26 because you signed a pleading that wasn't true, which Rule 26 says you are not allowed to do. Right? You can't use that violation for punishment under some other authority without following the Rule 26 process.
But the Court of Appeals disagreed with you on that point as well.
It did.
It is not an exclusive remedy.
Okay.
There's another remedy for unreasonable litigation.
Because every person that ever filed a frivolous lawsuit and Rule 26 was invoked, that would be the most ridiculous rule out there, because that means anybody can do anything and never have consequences. It would make the courts an even bigger circus. And one, I do think she filed a frivolous suit, but I think she was awarded attorney's fees for not only maybe the frivolous suit, but also for doctoring medical evidence, for lying and then not disclosing discovery when she should have, and she was court ordered to provide discovery. Those are the things that got her awarded, got Clayton awarded attorney's fees. All of it doesn't have to do with the fact that she's a lot like it has to do with she's a liar, but it doesn't have to do with this fully being frivolous. I mean, even if you took that part out, her conduct in the case is bad enough for other sanctions.
Litigation conduct, which within it can include the filing of a pleading that is not reasonable. But the court said it was more than that. There was a host of unreasonable things.
Yeah, she did have 10 days after
the
Rule
court
26,
refused
and she
to
filed
give Laura the safe harbor she was entitled to, and then it punished her for unreasonable conduct after it refused to let her drop the petition. If you think that makes sense, then you and I are just cut from different cloth. Okay. I've done a lot of litigation where people have engaged in sanctionable conduct, and I've asked for sanctions and tried to get punishment through any means possible. And I've never seen a court disregard the safe harbor provision and say, oh, I'm just going to sanction you $150,000 for doing something that was a violation of Rule 11, but I'm just going to call it something else.
Okay, so you sought sanctions under other statutes, no mention of Rule 26. And the court said, wait a minute, hold on. That could also be a violation of Rule 26. Therefore, I'm invoking a safe harbor with respect to a rule that doesn't have a statutory safe harbor.
You're not listening.
I'm totally listening.
We got to move on. We got to move on from that. I've asked for sanctions in cases, and courts just go, no. If a person withdraws a pleading, we're done.
Okay.
Because that's the safe harbor. That's what they give. That the safe harbor gives them a reward for doing the right thing. Laura never got that reward.
Under Rule 26, though, is the whole point.
If there was no paternity petition pending, how could she have acted unreasonably in litigating the petition?
Okay. There wasn't any paternity when she tried to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, we're talking in circles. We're talking in circles.
What about the fact? So let me just stop you there. What about the fact that she filed a request for mediation when she knew she was no longer pregnant?
When Clayton didn't have a lawyer.
I'm just asking you, what about that? Was that reasonable litigation conduct? What if Clayton consulted a lawyer at that point? Does he have to go to mediation?
What fees did that cause?
I'm asking you. What if he had consulted a lawyer at that point? Would that count?
What fees did that cause? Sorry, my phone's
No. I'm asking you. Right? Because we disagree on the causal connection requirement. If he consulted an attorney because of her request for mediation, and the court found that she filed, I'm asking you if. You asked me to engage in a hypothetical, I'm asking.
So I want to bring this up real quick. Let me make sure I go to the right place on this. Let's go to documents, and I want you all to look at this. So if we go to, all right, let me, 20 minutes. 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 remove. Okay, I'll bring that back up in just a minute. Okay, so we have on 1-3 motion for sanctions pursuant to Rule 26. Motion for rules of 26. This is where Clayton invoked Rule 26 in a separate motion, which it requires, right? Or so I did that. Then it is not until the 23rd that Owens responds. 20 days later. 20 days later. That Owens Owens says no. And then but if we go by the date that the separate motion on January 3rd, because we need to go by that date, not the first date that was ever mentioned, because this is when it starts. This is where she was given the safe harbor. That Rule 26 motion came after the motion to dismiss, because Laura moved to dismiss her petition a few days prior to the motion for sanctions. So, but none of this matters because this was taken off the table. And there were other things that needed to be done. Let me look again. 12:12. They mentioned Rule 26 in that. They did mention it in the 12:12 thing. But if we go by what Rule 26 requires, which it does require a separate motion all by itself, that didn't come after. That came after she dismissed it. At least it was entered. When was it signed? Did they even, let me see if they included the signature page on this. Da, 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 da. Where is... yeah, it was signed on the 3rd, the separate motion. But that would be an interesting question, Bruce, is does the notice start from the first time it is mentioned, or does it start once the separate motion for Rule 26 is posted? Once you've complied with all the steps in Rule 26, that is something I would like to know, and we should ask Omar, is when does that clock start for that 10 days? And is it 10 business days, or is it 10 just 10 calendar days? So that's something I would like to know. But the thing is it doesn't even matter because Rule 26 was taken off the table. But I mean, it's an area that we could all become more noticeable. In Rule 26 withdrawal, they probably starts counting on the 12th. And if she starts counting on the 12th, the 28th is well past that. So, but if they start counting from the motion, that would be the thing. So I would like to know when that clock actually starts. And I think that's a huge misunderstanding. We can always learn more. All right. Let's go back to this lovely video. Oh, we need to share screen. Duh.
Okay, if he consulted an attorney because a request for mediation had been filed, and she filed that knowing she was no longer pregnant, could she be sanctioned for that?
Not without following Rule 26, if that's the violation. Could he ask
128 USC 1927? I'm going to go ahead and find the safe harbor.
Did you read my discussion of 1927?
It's a different statute. I'm saying this is the closest that comes.
No,
it's the closest that it comes.
I know, but
you don't have any authority supporting your position. And so dicta for this case, which is not entirely on point, I agree with you. It's not a perfect analog.
My authority, Rachel, is that if Rule 26 gave Laura a right to stop the unreasonable conduct that Clayton believes was happening, that she had a right to stop it. She had a right to say, I waved the white flag for whatever reason, either because she admitted that the whole thing wasn't true, or just because she miscarried. Whatever the reason, she had a right to end the litigation under that safe harbor, and she was not given that right.
So if I file a copyright claim against Steve, okay, and then he files a counterclaim against me that I actually infringed his copyright.
I think it's funny she brings up a copyright claim against David
Gingras. And he has a request for affirmative relief.
Because we know how he is about those.
He files, he gives me notice, he serves whichever the applicable rule would be for, Rule 11 violation. And I say, okay, I'm withdrawing my pleading. That does not give me a right to stop the case.
Of course. I agree with you. But if your counterclaim was that the claim that was originally brought and then withdrawn was fraudulent, you win. You won. When Laura withdrew her petition and said, I'm not pregnant anymore, whatever Clayton's counterclaim was, he won. At that point, there was nothing to fight anymore. The issue that you guys wanted him to fight was, did she lie from the beginning? Was the whole thing a abusive process? Mata had no authority. She had no subject matter jurisdiction to decide a civil tort claim like that. The jury tried.
We just disagree that it's a civil tort claim. That's all.
Okay.
So to that point,
he thinks it should have just been a civil case.
Laura,
but
say not pregnant. There's no pregnancy here anymore.
Right.
When did she say it? When did she say it? The first pronouncement of that
case
fact was in her motion to dismiss on December 28th, which literally says petitioner is no longer pregnant.
Okay.
But way before my time, way before I was there.
Way before you there. The hookup happened.
Hear about way before I was here.
Hookup happened, we know, May 20th. Says found out 11 days later she was pregnant. That's kind of random, but anyway. May 20th hookup. December 28th.
Can I give you a little, the timing, the 11 days?
Yeah.
In my paternity case, when I got sued, it was 5 days.
Okay.
5 days. 5 days between the hookup and when she said she was pregnant. But go ahead.
May 20th hookup. December 28th.
I don't know if I'm believing that.
She says no longer pregnant.
Right.
And
correct.
I think you have stated
it wouldn't have been a
why
win.
didn't Clayton, basically you're saying, why didn't Clayton drop the case in December? Like when she said this, hey, there's no baby here anymore. Why are we even debating this? Why is this?
She said he was the father.
Okay.
Well, we still need to prove, was he the father or was he not?
That's 7 months. after this hookup
That
took
was
place.
what was the case was
This
about.
man was disparaged by this woman from the second she went to the Sun in September, and December 28th minus, and then on November 2nd, in a hearing, she stood up in front of a judge and said, "Judge, can I show Clayton my belly? I am 24 weeks pregnant. It is Clayton's. Here's my belly."
Right.
So on December 28th, when she says no longer pregnant, wouldn't
Yeah, the
you,
way
as
he
the man
tries
in this
to
situation who
back
has been
Laura
disparaged
here
by
is
her
so
for 7
ridiculous
months,
here in a minute.
wouldn't you just be like, well, I'm just going to dismiss this because you literally dragged me through the mud for 7 months. And if you are no longer pregnant now on December 28th, this isn't a 6 or 8 week pregnancy where you had some blood dribble out in a toilet. Sorry for the graphic nature.
There's static on y'all's
At
end.
7 months, where are these children?
Okay. You ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay.
How in the world was she 7 months pregnant and on November 2nd stood up with a belly and showed everybody, I've got a giant belly. I'm pregnant with twins. They are Clayton's. If she says she miscarried the next day on November 3rd, she's still 6 months pregnant.
Okay.
Where are these children?
All right. Can we take this one step at a time?
Yeah.
You and I talked about this before. And the issue that I have with what you just said, hang on, everyone's
my dog's
elsewhere.
working. Yeah, it's just-
What you're making is a very passionate plea that Laura did all these things and disparaged Clayton for months and months and months.
Yes.
And you have never heard me say that I think there should be no recourse for that. You've never heard me say that. You've never heard me say that that's okay. You've never heard me say that that's not actionable. What I've said
you
is
say
it's
that
not an
she's
issue for
telling the
family court.
truth.
That is a defamation claim or
still don't
something
think.
similar. Abusive process would fit this
Where
perfectly.
are the twins?
And Clayton could bring those claims, still could. The statutes run on defamation, but abusive process has a 2-year statute. He could still sue Laura. I mean, at this point, he has a judgment. You can't recover twice for the same thing. But what he could have done.
Okay. He says he could not win for the same thing. Well, the thing is, if he is collecting based on her filing a frivolous lawsuit, like in a paternity case, would it be the same thing if he sued her for defamation? It would be a different case because defamation would be on the crap she said. And he could win punitive damages and things like that. All he won here was trying to prove whether he was or was not the father. And he got attorney's fees. So he didn't win on the same case. Could they find that he possibly did? It's the same thing. Yeah. But also, he can now sue her for defamation for other stuff that she said, stuff she's put out since she has been found to be a liar. And she is knowingly putting false information out there that is not true. And a court says that it's not true. He could sue her because she's still out there bashing him. He could sue Gingras for continuing putting these ARPing allegations out here. And so those aren't the same things as winning attorney's fees because somebody said that they were pregnant and they weren't. He can sue her for many other things. He won't because he just wants this stuff to be done with and he's tired of her. And he knows that he's probably not going to ever see any money from her because his lawyer told him, which he gets into that. But I don't know that he's right here either. Like, I just don't know that he understands law. And that's coming from a non-lawyer, and I'm not an expert.
And what I think he should have done, if everything you're saying is true, if every word of what you just said is true, the remedy and the recourse would have been when Laura moved to dismiss a family law case, you go, fine, we're done in family court. Bye. Here's your summons.
I'm going to file a civil suit.
Here's your complaint and summons to appear in civil court where you have a jury trial right.
How would have that
more procedural protections than what family court gives you. And he could have gone through that process, and every single argument I'm making would go out the window. If you read the federal version of Rule 11, the committee comment notes under that literally say, and Rachel, I'm giving you a freebie here. The comment notes say, Rule 11 safe harbor does not protect against malicious prosecution
Give her
claims.
a freebie.
Of course.
Of course. So everything I'm saying, and I've said that from day one, I've never tried to say that you can't be sued for engaging in the safe harbor doesn't protect you. It just gives you a right to stop. It gives you a right to end the harm that you're allegedly causing and limit the damages. Okay. And Laura was never given that right to stop what allegedly was causing the damages. That's where, Rachel, that fact is why you and I are butting heads so strongly, because I don't understand how you think
what
it's
he's
okay
saying.
for a court to force a person to involuntarily
right.
litigate a claim and then punish them for involuntarily litigating a claim.
It made me understand him, because before I didn't even understand where he was coming from.
We just disagree, because I don't believe that Rule 26
but at
gives you
least
an absolute
I understand
right
what's going
to
on in his
stop
head. It just
and
doesn't
be
make
free
it
of
right.
sanctions under any authority if you've engaged in other offending conduct.
You're completely correct, with a couple of caveats and contingencies. If, like I said, if Laura engaged in unreasonable litigation conduct between
I'd like him to come to the
August 1 and
stand,
December 28th, and that unreasonable litigation conduct caused Clayton to incur fees, could he recover that? Absolutely. Absolutely he can. Yes. Okay. But not if the unreasonable conduct is signing a pleading in violation of Rule 26. That's where
we disagree.
Okay.
Yeah.
All right, let's move on. Steve, we got to
Can we get an answer to where the kids are?
Oh, so my take on that, my understanding of that is Laura miscarried earlier and just didn't know it. She miscarried probably, maybe even possibly before the case was filed. And before
the case was filed?
Did you not know that?
That she might have miscarried in July?
I believe that's what
How does Steve not know about the possibility she could have?
Then why do you do this and say, can I show my belly?
Miscarried in July.
How did she have a belly in November if she miscarried in July or August?
Have you seen the pictures of her body? That belly was real. The belly was real.
No, it wasn't. It went up over her boobs.
Exists for it? Our expert had no problem saying, I've seen that a million times. It's not common, but it happens.
Yeah.
Steve, I'm just telling you, man.
I know. But nobody thinks Medfield was worth a damn. He was awful up there on the trial.
This is my bigger question, right?
Your doctor also said he had urea.
Had an extremely high risk pregnancy and was pregnant with twins.
Yes.
She never sees a doctor.
She did see a doctor
around Christmas.
When?
Mom doc on November 14th, and she goes in and that's when the pregnancy was confirmed to be over.
November 14th. She claims to have conceived in May. And by the way, all the documents or all the things where she says, like, well, they asked me what date I conceived. Nobody asks you what date you conceived. They ask you the date of your last menstrual period. But regardless of that, she claims to have found out she was pregnant. What is it? The very end of May, Steve? Or
right.
May
20th was the hookup. Okay. And then June, it was either May 31st or June 1st, where she said,
May 31st. That is almost 6 months she went. May 31st to November 14th. There is no woman with a high risk pregnancy with access to medical care who does not see a doctor for the first 6 months of her pregnancy.
If they're keeping their child, you're right. And if they're not keeping their child, you're wrong. Women don't.
Why are you
go get
filing a court
when they're going to have an abortion? That's just if
you're not keeping your child.
Have an abortion 6 months later.
You're not.
No, I don't think so.
Clearly,
you are not filing a court case for a parenting plan if you are planning on getting an abortion. You're not doing that, because if you know or possibly are going to be getting an abortion, you are not going to file this parenting plan until you decide whether you're keeping it or not, because that would be dumb and a waste of money to be like, oh, well, I decided to abort them, so I'm just not going to go through with this parenting time. So this is bullshit. I mean, everybody knows it, but like, oh, she didn't see a doctor because she wasn't planning on keeping it. If you're not planning on keeping it, why do you need parenting time schedules and child support? If you're going to abort it, you're not going to court for that. If you're going to abort it, it's so stupid. And he's like, well, I don't know about them not asking for the conception date. Like, because we've never been pregnant. It doesn't take a rocket scientist to know that. If you've known anybody who's pregnant, you know this. Like, stop being dumb.
The pregnancy failed way earlier than we now know. Like it's easy for us to look back at this. At the time, Laura
you don't need a parenting
on
class
August 1st, which is really the starting point of this whole problem. She didn't know what her body was going to do in September, October, November. That hadn't happened yet.
Okay, but you're saying that she was never intending to keep the pregnancy.
No, I didn't say she was never intending to. That was the beginning of.
Just froze.
Did I? I froze?
You just froze. Say that again, Rachel.
And then anybody else is in, but
so,
Steve.
So I just said, how does she not see a doctor for 6 months? And you say, well, that's when someone is not intending to keep a pregnancy. Okay, but we know she never went in for an abortion. And if she really believed she was pregnant, if she really believed she was pregnant in September, that you're past the window. In October.
Look, at some point.
But I need to I want an answer to that. How does somebody who has a high risk pregnancy not see a doctor until the 6th month of pregnancy?
All I can tell you is, again, I wasn't her lawyer at the time. All I know is all these things were already done deals when I came along. Okay. So I wasn't there when all this occurred. I don't know. I didn't have conversations with her when this happened. I didn't know her then. I came involved months
It
later.
doesn't matter whether you knew her then or
all I can
not.
tell you is
It's
medically
still a part
our
of the
expert said
case.
nothing about this looks weird to him. I understand it looks weird to you because you started from the presumption that
I'm
she was
not
never pregnant to begin with.
so
She's
sure
a
that
liar because of
Mitchell isn't
Maritini and Gillespie say
senile
so. I don't
at
have
his
any
age.
knowledge of any of that. Okay. I came involved way after all this happened. And all I know is our doctor says she probably miscarried earlier and some of the placenta stayed inside of her body, which is why she still was testing positive for pregnancy.
The classic
which I think the last positive one was mid-September, Steve. You probably know. Mid-September. There was the 102 HCG, which then she changed it and made it higher and set that to
middle of October, I believe it was.
I don't think that's right.
Yeah, the 102 was in October for sure.
The 102 was in
You
October.
don't know of any of the facts in this case.
Regardless.
And you're
she
the
still hadn't
lawyer
sought
on
any
it.
medical care.
So weird.
Yeah. Well,
and your explanation for that is, well, you don't do that when you're going to terminate a pregnancy. But she was way past the point of being able to terminate at that point.
If you're right about that, I don't know. My wife has never been pregnant. I don't have any children, so I don't know.
But when you're taking on a case, shouldn't you know whether your client could or could not have had one? Because that would be an arguing point for you in your case. The fact that you didn't even look up the laws in Arizona on that is ridiculous. Like, it's malpractice. Like, you are doing such a disservice to your client. Also, oh dang it, I lost my train of thought here. What was I going to say? I don't know. If it comes back to me, I'll say it.
What the criteria are for when you're allowed to terminate or whatever. Look, all I can tell you is my knowledge of the facts of when the pregnancy ended, based on our expert testimony and his position, probably before the case was even filed, and Laura just didn't realize it. Okay, so, but again, ultimately, what does that have to do with the outcome of this case?
Okay, I remember what I was going to say. Okay, so my thing is Gingras took this case on, and there's a saying that says, when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have neither on your side, you pound your fists at the table. And so I think Gingras, because the facts are not on his side, and he knew the facts were not on his side when he came into this. So he said, okay, I'm going to argue the law. And so he didn't care about any of the facts. He just saw, okay, this Rule 26 thing, I'm going to argue that. And I'm going to say, well, she believed she was pregnant. And that she had a right to file this if she believed she was pregnant. So he came in, and I don't think he cares about any of the facts. The facts are not important to him. Like he said, he looks at the he looks at this like a patient on the table. So he just wants to argue those laws. He doesn't care about any of the facts surrounding it, because if the law says this is what you have to do in his mind. And the way he interprets the law is, this is what it says, so this is how it should be. He doesn't need the facts to be on his side to argue the law. And that's something that the appeals court doesn't care about either. The appeals court doesn't necessarily care about the facts of the case. They care about the law and whether it was followed. And so I think Gingras was coming at this like an appeal and ignoring all the facts. But the facts are important for this part of the case. So I get what he's trying to do. It just doesn't work here. You have bad facts to go with. And it's like, well, you can say he's doing the best that he can do with what he's got because he doesn't have a great case. He's being a douche about it, but he's trying to just stick to the law, and it just doesn't apply here. But he can try.
Did all of that cause $150,000 in fees to be needed, to be necessary, to be reasonable? I don't see it. Even if everything you're saying is right, Rachel, even if your entire theory is correct, that the whole thing was a sham from day one, she stopped it on December 28th. And again, like I've already said, Clayton could sue her for the conduct that she committed during that time period, separate and apart from anything in family court.
Okay, but she didn't stop it on December 28th.
She did. She tried to.
Right. Yes, she was going to dismiss with prejudice, right? But now her claim is that everything before that, right? She just stopped. She was basically going to stop the case, but then when she found out she wasn't pregnant, but instead she used the process of the court to request mediation. Why?
Which was denied.
Why did the court sanction her for that?
Well, by the 28th,
because there were no fees incurred from that.
And you're saying, I mean, that's the question, right? Didn't Clayton incur some fees? Couldn't he incur some fees before he had counsel appear for him?
If you're right, Rachel, then the outcome here is the judgment for 150 gets reversed and remanded and sent back for a recalculation of what fees were incurred from the unreasonable conduct while it was occurring.
But I don't think you made a causation argument in your appellate brief.
And he could have argued that. Like I said, if we want to give him a technicality and take out the Maricini fees, it's still a substantial amount of stuff. So even if he were to win on a recalculation, it doesn't change anything. She still would have to pay fees.
Well, look,
I didn't see one. You didn't challenge that issue on appeal. That wasn't before the court.
I totally disagree. But look, can we move on from something? I mean, we're just going in circles. I mean, like I've got Steve. I'll give you another 30 minutes. That's fine.
Losing.
But I just let me bring up one other thing. To me, I think Rule 26 is interesting. Structural error we've not talked about. I feel like that's worthy of a discussion. And Rachel, whatever strength or weakness you think exists in my Rule 26 analysis, I've not heard anybody, and the court, to the extent that it addressed it, I just emailed you, and I think you were kidding when you said you're wrong when I explained to you my view of what I found. That the court talked about the structural error after saying it didn't apply. The court cited this case called Emanuel and says, while a trial court's reliance on extrajudicial information may give rise to a claim of bias apart from structural error, see State versus Emanuel, the critical inquiry that would require reversal is whether the conduct demonstrates deep bias or deep-seated favoritism. The case that the court cited says
if you have been on any of my previous streams since the appeal, you know how I apply the structural error. And so this is where he is just way off base. I don't think he's going to get anybody to agree with him on this. So let's kind of scrub through this. Also, when he talks about this fact and he doesn't know where she got it, that it was in one of the filings. His blog is in one of the filings, and she can look at the things that are put in the filings. And his blog, where this could have been stated, was in those pleadings, in the motions. So she could have got it from there. And so him thinking that it's just all bad, and I've told you why. How do you prove bias if she researched this? Planned Parenthood was closed on Sunday because what if she was doing it to actually try to give Laura some credence to prove that she was actually telling the truth about that? How do you prove that she was doing it to prove that that Laura was a liar? You can't. It has no bearing.
The very first thing I filed was a request for extension of time to respond to Woodnick's motion to compel because I didn't have the file. I filed that the day I was hired. The very first day I was hired, I didn't have the file from Laura's prior counsel. I couldn't respond to a discovery motion that argued that disclosures had not been done because I didn't have the file. So I didn't know what disclosures had been done. So I make that request and she denied it without Woodnick even opposing it. You think that's normal, Rachel?
I can't say normal, no, but we have plenty
I've
of
never
family law judges here. We have plenty of family law judges here that want to move things along.
Okay, responding to a
Yeah,
request for
not
sanctions in the
the
form of a
only
motion
one.
to compel without giving me the courtesy of a brief extension that I had good cause to request. That's not normal. But look, hang
I
on,
would think that's not the norm.
wait,
I would think that's not the norm.
wait. That's issue 1 of 10. Okay. Woodnick then refuses to talk to me. Do you know how hard it is to litigate a case like this? When
No,
you're
he
new to the scene,
refuses
you
to
have trial
talk to
dates already coming up,
Owens.
and opposing counsel won't speak to you, which,
And he's
What
not
were you
going to do it
expecting?
on the phone.
oh my
He'll
God.
do it in black and white
do
writing
you know
where
how
he
many
can
hours
be
a day I spend on the
proved,
phone with opposing counsel talking about
and
every
nobody can
single possible
twist
issue,
anything.
settlement, witnesses, documents, discovery. All of these things require counsel to speak to each other. It's a professional requirement. Yes, you agree with me?
You can speak through email. There's
It's-
many
it's-
ways to
I think
communicate.
it's professional helpfulness. It's not necessarily a requirement. You know
It's-
that. But I
no.
agree. Look, I talk to opposing counsel all the time. Okay. But what were you going to resolve with them? Right?
Everything.
Laura was already given an opportunity prior to that for a free out.
Oh, with a big contingency. Yes, here, sign this thing.
Truth. Yeah.
The fact
Yeah,
is,
truth
so
was
hang
her
on.
way out.
I'm trying.
I'm just saying we're not going to agree on that.
She didn't
because
want to
You're
tell
going
the
to say,
truth.
well, you think she was lying, and I don't think she is. Like,
Steve, what I'm trying to tell you is in my forming of my opinion of Mata, it's not based on this one thing at trial, which is what you're trying to suggest. That is absolutely untrue. It is based on multiple
hurt my
rulings that she made that were completely, in my opinion, groundless, against what the rules require,
Nobody else has
and prejudicial to us
found that
for no
to be
apparent
true.
reason. That is what led me to say that I don't think she should be a judge, because it looks like she picked her favorite winner, I think sometime early on, and then made rulings to ensure that that guy won. That's what it
No,
looked and felt like
your
to me
person was
as a
just a
participant.
liar.
And that's not a good feeling. And that, I mean, do you think Laura or her family or
Blame it on
anyone
your
on our
client.
side thinks that the court worked here, that the process was fair here?
Well, of course they don't think that because she
Steve,
lost.
I've literally had JFC people reach out to me and tell me they absolutely see my point with Mata, that they think what Mata did was absolutely disgusting. I've had people that
Where
support
are these
Clayton
people?
reach out to me and say that. I have written DMs on Twitter from people that hate
You
Laura,
don't
that
think
think
he
that she
would
lied,
be-
and they say, you know what?
You cannot tell me that this has happened, because there's no way he would not have put this on Twitter, redacted the name, and put it on there. See, somebody believes this. Now, somebody in the so-called JFC could be like, oh, what did Owens send that to you from one of her fake accounts? You know, that would have been a comeback if he would have done something like this. But where are these people? And they can't say, oh, we're afraid to speak out because of what they're going to do. Like, nobody's going to do anything to you. But I just don't believe him. Like, he's not credible either.
Mata still, the way that she did this was not what a judge should be doing. And that's their opinion.
I don't know your other qualms with her other than her.
We don't have to
findings.
agree with
So I
everything
don't
that
know the whole
Mata
history of
did.
the bar
Yep.
complaint.
It
I haven't
doesn't
read her bar
mean that we
complaint against
think
you. I haven't
she
read
was
yours against her.
treated
So I can't
unfairly.
weigh in on anything. I don't think there was anything improper within that Planned Parenthood thing, but I understand your basis. You have a broader basis for complaining about her.
Yeah. And Steve, Steve, you probably know this, but the issue with, you said, well, you know, this fact that she found about Planned Parenthood's business hours, the fact isn't wrong, so it's no big deal, right? That's not the point.
Proof that there's something wrong with Mata. The roving room, every family law judge in Los Angeles.
Yeah, the
good
roving
ones,
room is
the
a
great ones,
joke.
and the not so good
I don't
ones
think you should
have
be
countless
leaving
reviews on roving room which
comments
say
on a roving
this person
room
took my
or
kids away
a
from me
Google
because I'm a man
review
and she hates
or a
men.
Yelp
This
review
woman took.
on something
I
or
don't.
someone you
I don't
haven't
believe a single one of
actually
those, even
had
for the judges that I don't think are as
connection with
wonderful
in
as
real
others.
life.
Okay, I think
Income is basically zero now. And she never said that she made 200,000. What she said was,
This is what I want to talk about.
So I want to go to Rachel with this first, but it's because it's something that you said. This came out of your mouth. In
All
the
right.
end of the video, you were talking about, Laura, I hope that you never pay Clayton.
Mhm.
Then you brought up the Trump situation. He
Mhm.
filed bankruptcy 6 times. He's famous for stiffing creditors. You could file a bankruptcy. Either way, there's no legal requirement for you to post bond if you don't have the money to be collected. And she said, I don't. I want to talk about this for a second, because in the trial, didn't Laura admit to having $200,000? Where did that money go? What do you mean she doesn't have any money? And this whole thing about, I'm just not going to pay? You don't want her to pay? You're telling your client, hey, ignore this payment of $150,000. I need a little more explanation on that. I think a lot of people do.
is that going to Rachel or to me?
no.
Actually, we'll go to you on this. Explain that.
So I'm glad you asked about it, because I think people, okay, here's what I'm going to say. And I tweeted to somebody, or I maybe responded on the YouTube comments to somebody that raised the exact same question. What I'm authorized to tell you is Laura does not have any money. Okay. She doesn't. Her income has basically been destroyed, and she blames JFC for this. She says that JFC has
McDonald's is
harassed her
always
podcast
hiring.
advertisers to the point that they won't work with her
She may
anymore.
think it's
And her
beneath
income is
her, but
basically zero
McDonald's is
now.
always
And she never said
hiring.
that she made 200,000. What she said was that was what the podcast made, and she split that with her mom. That's over now. Okay, that source of income is gone.
Oh, so the 200,000 she said at the trial, she no longer has for whatever reason.
She was saying that was her income from the podcast that she was doing with her mom. The podcast is not podcasting anymore. That you can't. I mean, I suppose you could do a podcast with no advertisers. You're not going to make any money.
Okay, maybe, then just correct me if I'm wrong here. I thought the judge asked her, how much do you have in some sort of account at this moment? Didn't they ask her that? And she said 200,000.
No, they asked about income, in her income.
I don't remember.
Anyway,
Right.
Steve, whatever the number was, whatever her income used to be,
she doesn't have it now. Okay.
Her income is zero, basically zero. Her assets, they are what they are. Clayton is entitled to go and look for that dude. He can collect his judgment all he wants. That's what the bond that people think that Laura has to post. The posting of a bond is only if you want to stop the plaintiff from collecting. Laura hasn't posted that bond because Clayton, you can't get blood from a stone. You can't get money from people that don't have it. So Steve, look, this has been a friendly conversation, and I don't have any problem with really anything you said, but don't say that I'm encouraging her to ignore an order. She's not sitting on 10 million in cash, and I'm just saying to her, go hide that. She doesn't have the money. She sent me a screenshot of her bank account the other day. I almost cried. And I feel bad for her. And all I was saying is, if she wanted to, and actually Laura asked me to bring this up, because in her mind, it weighs in her favor. And you probably will see exactly the opposite, because that seems to be the way we're going through this. I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Clayton's ability.
I don't think that the whole case goes away. And she's not Donald Trump. So maybe the things that Trump could get away with, and I'm not saying he should get away with everything, Owens is not going to get away with things that Trump gets away with. Whether Trump is a good person or a bad person, like, that's not even a thing. But she's not him. I don't think bankruptcy is her way
To do
out.
anything to her in court anymore stops the minute she files bankruptcy, and she won't do it. And she said, I'm not going to do that, as much as it would bring her relief and it would make my life easier, because I'm doing all this work for free, right? People.
So that's my question. Why?
Because I believe so strongly that she has been treated unfairly, and that what has happened here is wrong. I believe that in my.
If you're looking for somebody,
What she's done to somebody else isn't.
I mean, and that's one of the things I don't understand. Like, I mean, all you have to do is read a lot of these. You may say, I don't know if they're true. I don't know if they're accurate, but read what she has done to these men. Read the emails
He
with
hasn't
Clayton,
even
the emails with
invested,
Brett,
so I
the
don't
text messages with
understand
Mike.
how
You
he
have-
can say, oh,
you have
she's
admitted
untreated.
you know nothing about the Maricini case. You've never spoken to
Fairly
Mike. You've never
untreated.
spoken to Greg. You've never
I
read.
have never seen coercive control as badly as what she does to them.
Yes.
Okay.
So
Hold on, wait, just let me finish. Okay. All right. So there are a lot of people sitting in jail who have been treated unfairly by the system. Why not give your services to someone like that? Like, if you're doing this,
Yeah,
because
he's giving
you're
his
fighting
service
for what's
to a
right.
lost cause
I get that. But find
and not
find
knowing
a
all the
worthy
facts.
person.
Rachel, I have known Laura for 1 year now. I have worked on her case. Well, at the beginning was more intense. Obviously, it's kind of gone quiet because we're done with the litigation side of it. But she has become a friend. I talk to her often. I have spent a lot of time with her, way more. I mean, you guys have no knowledge that I do as far as contacting with her personally. In the last year, I don't know the person that you're describing, I guess is what I'm saying. I've never seen her behave other than reacting when Dave Neal makes a video and just rips into her. She is emotionally devastated by that. And I keep saying I can't judge how she's reacting, because anybody that went through something like what she's going through, I think would react badly. But in terms of her, Rachel, what you just said, her coercive, controlling behavior and all this and so forth, I've seen none of that. She's certainly never acted that way towards me.
She's being wrongly
Okay?
accused, but she's not being wrongly accused.
Why?
You got to entertain us then. You have to go look at this stuff and then come back and say,
Because it's kind of hard.
this is huge, because Rachel, the point that you and I talked about, tell him what we were talking about in regards to this.
Look, I agree that everybody deserves representation. Everybody, I don't fault a lawyer for
If you need to
representing
slow
them
down on your end, you can
somebody who's on the
slow
wrong
down
side
on
of an
your
argument,
end.
right?
I
Because that's what
want
lawyers do.
everybody to be able to go to
But
Lauren's
you've gone beyond,
stream.
right? I mean, you have, what you said was, I hope Clayton never gets paid. I can't believe what he's done to you. I can't believe this is so terrible. It's so hard. You've given her a platform. You've put her on your videos. You've sort of given her a platform to put forth this victim mindset. I've been victimized by these men. I've been victimized by the system, right?
To respond to people making that claim.
I mean, I want to read you a sentence, right? I would still get a surgical abortion this week and drop the case if you choose to pursue the relationship you claim to want with me. That is so manipulative. And that's from an email from her to Greg Gillespie that I believe was from her to Greg Gillespie. I can't myself verify that it is, but something that purports to be, right? I mean, why is this a person that you want to put forward and say is deserving of our sympathy because of all the people that have victimized her?
Rachel, if women treating men badly is a legal issue that warrants financial destruction and social media harassment for any woman who treats a guy badly, if that's how you see it, I don't see it as a legal issue for the courts unless something becomes criminal or is harassing. And Clayton has his order of protection. Laura has not done this. All of these events that you're describing happened almost 2 years ago, right? And
but Laura's the one that brought all these things into court. Laura was the one that dragged these men into court for abortion coercion.
Years ago.
Right.
And she's not doing that anymore. So leave her alone. Let her.
How do we know she's not going to do it again?
This is where he's lying. She's not doing any of that anymore. She's not trying to keep this going. She's not doing this anymore. Bullshit, because she just renewed her order of protection against Greg Gillespie. So don't sit here and say that this is in the past and she's not doing this stuff anymore. Because if she wasn't doing it anymore, she wouldn't be renewing these orders of protection because they're not real. So give me a break on that's the old Laura. New Laura is nothing like that because it's just not true. It's a crock of crap and you know it.
She's done it 3 times with 3 men. How do we know she's not going to do it again?
Okay, well, guys, I'm not in charge of Laura's love life or her future. That's between her and whoever wants to date her. That's not a legal issue that as a lawyer I have any concern over. I will tell you, Rachel, I agree with you that I have read some things that Laura did and wrote to Clayton that I don't endorse. And I'm sure that if somebody went through your entire life, history of emailing men or whatever, no, really, you've been perfect your whole life?
Never said anything that.
Never told someone that if they date me, I'll have an abortion.
Yeah, okay.
Nothing like that.
I'm not endorsing every little thing here, but I'm also saying I don't care. This is such a private life issue.
You would never find.
And again, it became an issue because she went to court over, and that's her fault. I'm not asking. Yeah. And she reaps what she sows. I give you guys that. I give you guys that. But at some point, she has tried to stop this with Clayton, and you guys haven't let her.
Then why not have her sign a judgment confession? Why not have her sign? Why not have her say, look,
because she is going after Greg Gillespie still.
Say, I'm broke. Fine, enter judgment against me. I'm broke.
There already is a judgment against her. She doesn't have to see that.
Right. You're totally right. She can just stop the appeal. I was just kind of fast tracking everything. You're right. Just let go of the appeal. Just stop it.
She
never collect it.
You guys, all that I can tell you is she feels that she has not been treated fairly, that the law's not been followed. And I agree with her. You don't agree with me.
Feelings aren't facts.
We'll figure out who's right and wrong.
She treated Clayton fairly?
I think it's a personal issue that is just not my part to judge.
But she brought it to the courts.
Rachel, if I had been involved in this from day one, every single aspect of this would have been handled differently. And I have no problem with Clayton feeling angry. I have no problem with that. I'm not taking anything away from that guy's right to feel whatever he's feeling. What I'm concerned with is using, I have a completely different outlook on what this case really was. I think this was Greg Woodnick getting revenge against Laura for her emailing the judge in the Gillespie case and saying, oh, I think Woodnick was involved in me being raped. That's what I think
because
really went down here. That's why else would Clayton.
Not the whole case. I mean, the latter.
Going to accuse.
Not the whole case.
Correct. No. Since Woodnick got involved.
It's not revenge.
That to me, and what Woodnick has done to use this case as a vehicle to exact revenge against Laura, I think is actionable. I think that is abusive process. But that's my opinion. And Laura wants me to sue Woodnick right now. And obviously I haven't done that.
It's just another allegation.
I'm actually more of a peacemaker. I would like to see everyone stop this and leave it.
He has nothing.
And why is she threatening all these people with lawsuits?
Yeah.
Because they're
why are you don't threaten with a lawsuit? Don't threaten this podcast studio with a lawsuit.
Rachel, people have a right at some point. They have a right to privacy. Laura says that Dave Neal has lied about her. She says that.
She wants a right to privacy, but she wants to keep putting out Medium blog posts. Give me a break. She wants her cake and eat it too.
Okay. I don't want to get all of that. We need 3 more hours. But Laura has a right at some point to say to people, leave me alone. I'm not going to be your punching bag forever. She's gone through hell.
Then why is she still posting blogs?
Why is she posting blogs? Why is she going on your videos? If it's so mentally drained for her and bad for her mental health, why are you putting her on your videos?
All she's doing is responding to things. Okay. If JFC would leave her alone, she would never post anything again, probably.
You know what all of us have been doing? Everybody in JFC. Let's see. Megan Fox has been covering What the Hales. I have been covering Karen Reed, Sandra Birchmore. Lauren has been covering Baldoni. Dave Neal has been covering Baldoni and other pop culture Bachelor stuff. Bruce has covered Bachelor stuff. Tilted Lawyer does his Vlads and other things. none of us are solely dogging on her. We start to talk about her when she does things. Like she got brought up. One, yeah, the appeal, because we're, discussing finality. But also, she gets brought back up because she went to renew her protection order against Greg. So stop saying this is all because JFC won't stop. She is in the driver's seat with this.
Probably, unless it was about horses or country music. Okay, but if you guys make statements about her or attack me or the Court of Appeals, Laura has a right to let people know what her side of the story is. We've done that. So look, I would like to see. I love cases being resolved. I don't want this to go on for another year. I don't.
Give her opinions.
But Clayton and Woodennick have given us no choice. If they want to talk, I don't want to talk to Woodennick. I'm happy to talk to Marcus or anybody else from. I have no problem with those people. I mean, guys, as much as this has been a little bit of a heated debate, I think I'm a reasonable person. I may take positions that you don't agree with, and maybe ultimately I wind up being wrong. But I don't think I'm that hard to talk to, Steve. I mean, you and I have talked. Have our conversations been okay in your opinion?
No, every time I've talked about the fact that our conversations they were never contentious. I didn't agree with a lot of what you said. You didn't agree with a lot of what I said, but I said they were never contentious. But my main point with you has always been the David Gingras that I deal with on the phone is a completely different person than the guy on his blog, on his tweets, and on his YouTube channel, because you come across as a giant asshole.
Totally.
And you don't do that, at least in the conversations with me. I think there are people that will watch today's video and get fed up with your sighing and get fed up with your interruptions of Rachel. But that's a completely different thing. But between me and you, our phone conversations have been perfectly fine. But it's just when it gets to when I read your tweets, when I read your blog, when I watch your videos, I'm like, he's just a different person. This isn't the guy that I talk to. And I don't know why he takes this persona of chest thumping and I'm always right and you are all idiots and you're all a cult. And you call JFC a cult. And honestly, they have learned so much more about this case than you even know. So clearly they're doing something right.
Okay, so just to close out with one final thought. You guys have made some kind of moral arguments, and Rachel, you talking about, Laura sent an email to Clayton saying, whatever she said about abortion and whatever.
Oh, that was to Greg.
That was great. Yeah.
Oh, okay.
One of like 7 or 8 sent within a several day time frame.
Sometimes the law and morality.
Right. Okay. You're aware of things that JFC has done in retaliation or response to what Laura, sending a flyer to her gym saying warning with, have you seen that flyer, Steve?
Yes, totally wrong. I don't agree with that at all. I agree with you.
We still don't even know if that actually happened.
To send any flyer, though I have not seen that one.
And if somebody, I don't agree.
Calling the police and asking for a welfare check, and then getting the body cam video and putting it on YouTube and laughing about it when they're standing there in their Christmas outfits.
That's another lie.
Is that okay? I'm just saying. So, Steve, the reason I'm bringing this up is because you asked, why am I like kind of reasonable and sitting here talking to you, or at least friendly enough, and then why am I a jerk online? Right. And the answer to why I'm a jerk online is when I'm tweeting or responding to people, it's usually because some event like that has happened. I have Laura in my ear crying. I have her begging me, can you make these monsters stop attacking me? And I do get upset about it. I feel bad for her. And I get a little emotional. We all do. But that's what you see. That's when I'm responding to somebody after something's happened that makes me feel the need to respond. You're not getting the best version of me. I admit that, Steve. I fully admit that. And I'll tell you, I give you my apologies for I've never been rude to you. I don't think I have.
That's your job as a lawyer, to be professional.
I don't mind.
It was the gloating part. It was the loss and putting up your clips of saying no way in hell Clayton's going to win. And I gloated because you got your ass kicked on a case.
I think the San Francisco 49ers are going to win the Super Bowl.
He doesn't know.
All I'm saying to you is,
that's ridiculous. Come on.
It is ridiculous. It's intentionally ridiculous.
So then what was the point of that then?
Because what you guys act like all Laura had to do back at the beginning was sign a statement saying I was never pregnant, and then Clayton would have let her out. That is exactly the same thing as Laura saying to Clayton, here, sign something saying that you raped me, and I'll drop the appeal. Clayton knows he stuck it in or not.
If he did that, why
raped her?
Why didn't she file criminal charges on him?
Confess to a crime?
It's intentionally absurd what I'm suggesting, Rachel.
Because
he still keeps bringing that up.
The truth is,
it didn't happen.
I think from everything we can tell, that she wasn't pregnant.
But was she sexually assaulted? You don't know. I don't know, and I'm not making that claim. I'm just telling you that what Laura was suggesting that Laura do is exactly the same thing as her asking Clayton to admit, oh yeah, I did sexually assault her. He's never going to admit that, and Laura's never going to admit that she lied about her pregnancy. So we have that.
I understand that. I understand that she's never going to do that. But that's a way out for her. Is to admit it.
To admit something, to get fees. And
let's see.
I see it that way too. I know you.
So she's basically doing what you criticize Clayton for doing. Perpetuating it just to vindicate oneself.
No, the difference is that Laura has actually suffered damage that Clayton didn't suffer. Clayton didn't. When Laura moved to dismiss the petition, Clayton did not have $150,000.
He lost.
You know that.
I agree.
He still lost money paying gigs.
Laura does have the actual damages of the fees that she's paid me, which are tens of thousands of dollars. She has the actual damage to her reputation.
His name was bashed.
From all this ongoing.
He lost out on business opportunities.
Could it be remedied in another way?
But why are you raising it in support of what you're perpetuating?
She brought this on herself.
It's no different. I'm saying, Laura has an argument to make, and she's making it. But look, if we could find a way to end this thing, I would be the happiest guy in the world.
But can't we?
Yeah.
I don't know. Then they emerge from it, and I'm focused on the future. Okay, the past is interesting. I'm not telling you it's not relevant to anything. But if Laura can get herself to a better place and leave all this behind and not engage in any conduct that looks weird, which is my experience with her, that's what I want to focus on. So that's where I'm coming from. I'm a forward-looking guy. You can't tell me that the mistakes you made in the past define you today. If you're willing to change, and her nephew, and she is just a normal person who's maybe gone through some weird stuff and maybe did some things that she shouldn't have. Maybe. Okay. But to keep tearing her down when I feel like, look, I'm not seeing the conduct that you're describing. If I saw it,
the things I took from
I'm
today
sorry
is
that you're not.
You think this should have been? Maybe I'm putting it out there. You think he should, or you think he should have, or should file a civil lawsuit against her or a defamation lawsuit against her? You know what, Rachel, you're right. Nor did I think you were going to ever say anything that she was going to say in this.
Okay. So that is the gist of what was done. Gingras did get into an argument with me about because I had a problem with him telling his client that she shouldn't pay, because he said that out of and being revengeful, that Clayton doesn't deserve to be paid. He didn't say it because she's judgment proof. And also, she has no money. Well, there are plenty of places that are hiring that she could go get a job. She chooses to be jobless. So that's on her. She chooses to mooch off of her parents. But that is going to be it for me. I am hoping that this sends you into Lauren's stream. Put some little chick ducky emojis in the chat for Lauren. Hopefully it redirects you. I think I did it correctly. If not, still go check her out, Lauren 90, and I will see y'all over there. Bye.
I maybe be angry, jealous, or in love. Make sure outsiders don't ruin the reputation and reveal our secrets. They need to be stopped, or the truth will come out. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time and a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity. The motive, the means, and the opportunity. Motive means opportunity. I have the knowledge, the skill, the support, the tools to become a killer. Motive means opportunity. Now the opportunity reveals itself by time and a shady alibi. I have no reason to explain the things that I do. Can I do the crime in the time? Can I cover this up, or does this mean we're corrupt? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity. Do I have the motive, the means, and the opportunity? Motive means opportunity.